to travel, your lordship, my lord, under the compelling circumstances. The petitioner, one of the petitioners is 82 years old. For the last 21 years, I am moving this court, my lord, for the purpose of compensation. No matter, let it appear under the heading, my lord, the mentioned matter.
It's at the motion stage.
At the motion stage, my lord, I have filed it. Your lordship was kind enough to direct the matter from combined list to, my lord, the supplementary list, my lord. So, my lord, let it appear at the motion stage. My lord, only one report will suffice, because this matter was disposed by your lordship. Category directed them not to take any other plea, but to determine the compensation. In spite of that, my lord, they were taken a plea of, my lord, the vesting. Without,
But it is in the supplementary list.
my lord, kindly let it, my lord, it's 89, my lord. Ladies, my lord,
89,
my lord, I will never pray before your lordship, my lord, anymore.
It's not very far away, because what is happening is now the mentioning list is getting longer.
Yes, that's
So the
true.
same thing will happen.
So, my lord,
Please wait. 89 is not very far away. Let me see.
may I wait for another 7 days, my lord?
Let me see. Let me see. I think I can take up.
May I have your lordship's leave, my lord? I'm sorry to trouble your lordship. My lord, these two hearing matters of 2019, my lord, both were with regard to resumption of land and where board has been affixed that this is government land. My lord, lordship, after hearing the urgency in both these matters, my lord was pleased to direct the matters on 3 occasions to appear in the supplementary list. My lord, adjournment was sought for, went down the list. Now, on the last occasion, my lord, I was caught up in another court. My junior was here, but I did not appear. The lordship has directed both these matters to appear on the 27th of September. I had mentioned, lordship, please to direct me to mention any other day.
27th September is this month. I will not prepone. Please come.
My lord,
Who is appearing for the state in this matter? Have you put them on notice? Put them on notice so that they are aware that they have not filed affidavits. Please mention on Monday after informing the state.
my lord, in regard,
I can ask the state to comply.
my lord, in regard to
Give the number.
my lord, in regard to item number 601 of the test list.
My lord, may I be permitted to mention, my lord, one matter, my lord. One of the difficulties, my lord, the third party interest right now is, my lord, being created, my lord, on a property, my lord, which is located in the Noyanjo. And unless, my lord, this is, my lord, taken up, my lord,
It's in the monthly list. Give the
My lord, in regard to item number 601 of this my lord, monthly list, my lord, the urgency is this, my lord, that there is a long-term mining list which is going to be expired shortly, my lord. The matter would be infructuous due to the COVID and the, my lord, the law and order situation. We could not, my lord.
You're asking for extension?
Yes, my lord.
Give the number, please.
Well, it's a restoration.
Give the number.
Great.
Already passed. I filed 10-4. I am covered by your lordship that until that decided.
Yes.
What? Yes, my lord, on 4th I already submitted. If your lordship kindly direct the matter appear pencil matter, then I again sub and came back.
They again?
I sub notice, my lord, if your lordship
What
kindly.
is your urgency? You have filed
My lord,
10-4.
because 10-4 already pending day, my lord, 15th is the last date. My lord, to take coercive steps against my.
Give the number. Give the number, please.
May I be allowed to mention, my lord?
Give the number.
The matter is about senior citizen, my lord. In spite of mentioning once, the matter has been not hard yet. The matter demands also urgent hearing due to the result, my lord.
It is in the supplementary list?
Running, but not hard yet.
It is in the supplementary list?
Yes, my lord.
So please wait. Supplementary list matters will not be updated.
May I
one matter, my lord?
Yes, so it will be taken up. Please wait.
May I mention one matter, my lord? Monthly list, my lord, 6357. In the month of March, I have filed this application, my
Motion.
new motion.
Give the number.
My lord, item number 223 to 225, my lord, analogous matter, my lord. My lord, demolition date is Monday, my lord. My lord, earlier occasion, your lordship had the matter, my lord, since every of service was not there, my lord. Your lordship fixed the matter today, my lord. But
It's in the supplementary list?
yes, my lord.
In the supplementary list? So please wait. It
My
will
lord,
take up.
Monday is the last day of demolition.
the
Can you
notice?
see, my lord?
Where is the notice?
Can you see, my lord? 7 days notice, my lord. On 28th, the demolition notice was served, my lord. The date is mentioned there 17th, but it has been served on 28th. But kindly take it on Monday, my lord. Otherwise, matter will be My shop room will be, my lord, demolished, my lord.
দিদি এটা সোমবার উপরে দিকে
Pilot may permitted to mention.
One matter, minor.
Yes, sir.
Pilot is permitted to mention.
Wait,
pilot.
wait,
This is
wait.
the monthly lease matter
Madam.
pilot for upgradation matter.
ওইটা দিয়ে দিন না
Land
একটু।
has been acquired matter since long, no competition.
না
is
তিনটে
pending,
তিনটে।
and the main fact is that the petitioner is the senior citizen matter, more than 70 years matter.
give the number.
May I have your lordship's kind leave to mention in regard to item number 723 of combined monthly list manner, the urgency is, my lord. Already the private respondent has encroached upon PWD land and which causing the unauthorized obstruction in front of my land. A new building is also being construction of new
Give the
building.
number, give the number.
If
please.
you-
Lordship, may I be permitted to mention, Manor, the matter is related to a senior citizen. Manor, your lordship has given an order to dispense the compensation regarding the under the Rehabilitation Act. But they have not given any compensation till date, and kind of please be enough
So
to,
you have filed a fresh repetition.
yes,
Is it in the monthly list?
no, Manor, the today's list in item number 117.
Please wait, it will be taken up. 2 days, please do not
May I have a
mention.
lordship, can I leave to mention one matter appearing in 934 of the monthly combined list, my lord. In spite of order of this honorable court, my two-story building was demolished. My lord, this matter was moved on a holiday leave granted by the then Chief Justice, my lord, Jyotirmoy Bhattacharya, my lord. And my lord, Honorable Justice Harish Tandon passed and stay order. In spite of that, my lord, my two-story building was demolished, my lord. I am in the
Is it
street, my lord,
appearing as
kindly give.
Is it appearing as a hearing matter?
Yes, my lord, kindly give, my lord.
It's in the
Update-
monthly list.
Yes, my lord.
Give the number.
My lord.
Yes, call the days
Wait,
list,
my
please.
lord.
Let me see. Call the days list, please. I should want.
Well, I'm appearing on behalf of the petitioners. I mentioned for correction, little correction, my lord, that the typical error.
Did you put the other side on notice?
Yes, yes, I informed all the one. Only
The-
typical error. I mentioned me, Mr. Debra, I just morning told, well, to correction matter is not necessary for break. And also.
It's
my lord,
substantial correction. It is necessary, Mr. Khan.
I inform, they assure me.
What
they
is
will-
the correction?
Well, kindly see first page,
Yes,
fourth paragraph, last line, next page, page number 2. Reciprocal transport agreement instead of transfer, it will be my lord, transport.
yes.
Reciprocal,
Page 1,
page 2,
page 2,
yes, first line,
yes.
reciprocal transport agreement, here a transfer agreement, but transfer, it will,
The first line is STA Jharkhand by a letter issued on 7th. That is the first line.
no, the reciprocal transport agreement, not the transfer agreement. It will, my lord, instead of transfer, it will be transport agreement.
The first line,
Page number 2,
page number 2, third paragraph. Why are you saying first
yes,
line?
third paragraph. The running on to Katragas was not included in the reciprocal transfer agreement. It will be transport agreement, not transfer.
Clause 8F of the reciprocal
eight.
transport, yes.
Yes. And next, my lord, page number 2, third paragraph, also same mistake. Reciprocal
Transfer, yes.
transfer.
yes.
And also next paragraph, reciprocal transfer agreement, it will be transport. Or 3 paragraph, no correction, like nothing else. Instead of transfer, it will be transport. In the agreement also, I manage, the agreement also transport. Can you see the agreement? Reciprocal transport agreement, page number
So in
53.
2 places, there is a mistake.
Three paragraph.
What is the third paragraph?
Third paragraph, last line,
Third
reciprocal-
paragraph, last line, fourth paragraph, last line.
last line.
Then-
And also
then-
fifth paragraph also.
Fifth paragraph, which line?
Strangely enough, the state Jharkhand committed, continue to countersign the permit the transport till such date, being included in the reciprocal transport agreement.
I do not find. Please read out the last paragraph. It starts with be that as it may.
No, just above this paragraph, strangely enough,
Yes, that is, yes.
the STA Jharkhand continue to countersign the permit of the petitioner till 2018 despite the route not being included in the reciprocal transfer agreement.
That is one correction and above that there is one correction. There are 2 corrections.
No,
There is the
3
third
correction
correction.
also paragraph 3. First paragraph, first page. Third paragraph. And next page in the concluding with the paragraph, the end of the
Yes,
first
yes.
line. The
Uh,
transfer.
The matter has come up under the heading to be mentioned at the instance of the petitioner. Paragraph inadvertent error has crept into the order passed on 30th August 2023. Paragraph in the fourth paragraph of the first page of the order.
Yes.
And the third and fourth paragraphs of the second page of the order, comma, reciprocal transfer agreement, inverted comma rakhun, be read as reciprocal transport agreement. Transport agreement. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 30th August 2023. Urgent certified website copy.
Review.
Item 2.
My lord, in this matter, Gautam Banerjee appearing for the petitioner is admitted to hospital, my lord. I'm paying not to date.
On prayer of the applicant, the matter is adjourned. Let the matter appear under the same heading on 3rd October. Item 3.
Lordship, in this matter, I am appearing for the petitioner, Lordship. This is the contempt application. First time it has come. Lordship.
Please serve and come back.
Yes, Lordship.
28th September.
28th September. Grateful, Lordship.
Wait.
28.
Item 4.
I'm for the petitioner, my lord. This is same prayer, my lord.
First time.
Yes.
28th September. Please serve and come back.
Yes.
5.
My lord, I am for the petitioner. My lord,
Yes.
this is regarding the quantum of award given to me. My land was acquired by the state.
Who is appearing for the respondents, Mr. Dev? Yes.
The difficulty is that they have passed the award.
Take the microphone, please.
Yes, they have passed the award, which is much below the market rate. And before your lordship that if they make a fresh award as per the market rate, prevailing market rate. My lord, I have given my representation.
Is it under the 1894 Act?
Yes, my lord, it was the under the 1894 Act. Then subsequently we filed a case before your lordship. It was under, then it was transferred to Fair Compensation Act, under the Fair Compensation Act. And they were directed to pass an award. They passed an award under this Fair Compensation Act, and we received the award, my lord. There was a order dated 16/9/2022 at page 111. We were protected that we can receive the quantum of award without any prejudice and contentions. Page 111.
Yes.
My lord, page 111, the last paragraph. Mr. Mitra, learned advocate for the
Yes.
petitioner says that since this client proposes to file an appeal against the quantum of award, the petitioner should be permitted to accept any payment from the state alleged contender without prejudice to the right and contentions. It was clarified that and payment that they may receive will be without prejudice to the rights and contentions. And we received it. But we were dissatisfied with the quantum of award they have given because it was not at all as per the market value. My lord, we filed a representation at page, my lord, 258, my lord.
258.
258. And to that extent, at 262, they turned down our representation, stating
This is a demand of justice. This is not a representation.
it was a demand of justice.
You have no representation filed.
No, my lord, we have given the no, my lord, we have given the demand of justice. To that extent, they have filed the reply, turning down our representation at page 262. My lord, the last paragraph as regard application number 64, right of fair compensation and transparency in land acquisition, rehabilitation, and resettlement, Act 2013.
your client do not fulfill into the category of any person interested who has not accepted the award as he has accepted the award. Hence, no action can be taken under 64 of the new Act of 2020.
Yes.
It is absolutely perverse.
What is your prayer?
My
For
prayer-
reconsideration?
Yes, madam, to file a fresh award, stating the current, market value. But to that extent, we have filed a, report of a valuer also at page 262.
What is the order referred to here?
Madam, that,
The MAT, the FMA, 30th March 2022 order.
30. Yes, madam.
In rejecting your prayer, an order has been referred to by the authority.
Yes, madam.
FMA?
It is at page.
Where is that order?
Yes, my lord. It is at page 86, my lord. It is at page 86. My lord, the operative portion, my lord, is at 102. 102, paragraph 27 and 28. My lord, here, my lord, at page,
Yes, let us hear Mr. Dey.
What is the order? 262, my lord, there is a, after that, my lord, 263. That is the Shorbuji Doctor 263.
263 is a valuation report.
my lord, we have given that evaluation report just for.
That order is passed, my lord, 262.
Yes.
As regards classification, application under section 64 of right of fair compensation and transparency of the acquisition, rehabilitation, resettlement and your client do not fall into the category of any person
My lord, I am led by Mr. Arindam.
who has not accepted the award. As he has accepted the award, hence no action can be taken under section 64 of the rule.
Award,
Now, the short point involved is whether by taking those monies during the pendency of the proceedings in terms of orders of court, protecting my right, I can be said to have accepted the award. That's the short point. I'm sure my learned senior friend will also know. The only thing I want is that there is a provision for a reference. There are two things I can seek, Lord, but I am trying to expedite things. There are two things. One is the award or that extract of it that has been given to me. Ex specie shows that there has been no application of the provisions of the new act in the manner that it is done. The new act is absolutely exhaustive. It lays down what has to be done, the various heads and the manner of computation. My lord will find ex specie from the award that has not been complied. So my best case scenario would have been to go back so that I am heard in support of an award and an award be made.
Yes, my lord, he has been.
And the only point taken by the authorities, they have accepted the award.
Now,
But that was without rights, without
that was
prejudice
without
to
prejudice to rights and
context. In terms of the order of the
Because
court.
that is, my lord,
Let it be reconsidered.
yes, my lord, reconsider.
Yes.
let this be done.
Where
And
is the order of the court which directed you to receive the award?
the page bolo
111.
kindly come to
111?
page 111 তার আগেও ট্রায়াল কোর্টেরও আছে দেখো দাও ফার্স্ট কোর্টেরও আছে
It, oh, first quarter.
The division bench is ordered, isn't it? 111.
Division bench order.
please come to 111 order
Yes.
starts at 109
Yes.
last paragraph.
Yes, I've seen that. Being aggrieved by the compensation paid to the petitioners for acquisition of their land, comma. The petitioners
তো দাদা রেফারেন্সের অথরিটি তো তৈরি হয়নি তো এখনো। অনেকটাই আরেকবার রিকনসিডার করুক। আমি তো দিয়ে দিলাম সব বিষয়। কিন্তু রেজিস্টার ডিউটা একটা ভালো দেখে দিও, যাতে বেশি দাম হচ্ছে।
Filed an app,
মার্কেট
filed
ভ্যালু
an
কিন্তু
application
তোমরা রেজিস্টার ডিউ দেখাতে পারো।
before
500
the
টাকা
concerned authority,
বেশি দামের রেজিস্টার ডিউ, তাহলে হবে না তো। যা এ দেবে
to
রেজিস্টার
their learned
অফিস থেকে
counsel.
তাই আমাকে দিতে হবে।
On 20th January 2023,
এটা পাঁচ চলছে।
seeking a reference either under section 18 of the Land Acquisition Act or under section 64 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Land Acquisition Act, 1894.
রিকনসিডার। তাহলে তো ওটা তো আবার
The
section
petition-
64 forum has not been constituted yet, though it's a provision in the statute. Therefore, my lord, perhaps my learned senior friend will not disagree if the matter goes back to the authority which had passed the award to consider me, my lord, and to pass an award afresh. Because the 64 forum has not yet been
The
constituted.
reference was made before the said of the same
The reference
authority.
was made before the reference forum. There's an appropriate authority, which is the reference forum. Now that appropriate authority has not been
The
considered.
first, it was made before the first land acquisition collector.
Yes, but not for the purpose of referring it to the 64 authority. Now that section 64 authority, which was the civil court under the old act, this authority I am instructed, not I have taken instructions, has not yet been constituted.
But
therefore-
since I'm sending it for a reconsideration.
Then kindly
it
send it
has
before
to
the
go
first
before-
forum.
It has to go before the same authority,
Yes, the first forum. Yes,
the first land acquisition collector.
yes, reconsideration. Lord. And kindly set aside that part of the award which deals with my case, so that he can reconsider and pass afresh. Only that much.
There's nothing wrong with the first paragraph saying that section 18 will not be applicable.
Yes,
Because the
Eight-
court says it should be dealt with under the 2013 Act.
under the 2013 Act. So 18 or,
Let the second paragraph be set aside and
yes,
let it be reconsidered.
and let it be reconsidered, my lord, by the first forum. Your lordship will also have to, my lord, in the process perhaps. for this-
That is the person who passed the order, that he
Yes.
will reconsider.
Please take 113 just once, my lord. Just, my lord, to absolve this doubt, my lord, before your lordship finishes.
113. Yes.
Lordship has seen, my lord, this is an annexure to the memo.
The same person. This is the first.
So
first
this
land
has to be
acquisition
set aside
collector,
and
yes.
sent back to him.
Yes. কি বললাম আমি? Sentence টা কি বলবো? Being agreed by, oh, applied before the year, with the reference and stop it. The petitioner's essay per apostrophe prayer was turned down by the authority on twofold grounds. By a letter issued on 3rd March. This is 2023,
Yes.
3rd March 2023. Colon dash. Section 18 of the Land Acquisition Act 1894 was not applicable in the case of the petitioners in view of the judgment of this court passed on 30th March 2022 in FMA 1793 of 2018 and of 2018, and since the petitioners accepted the award, they could not have taken recourse to section 64 of the Act of 2013. Stop. It is submitted on behalf of the petitioners that the award was received by the petitioners in terms of the order passed by an honorable division bench of this court in
FMA 1793 or 28.
CPAN 621 of 2022, in FMA 1793 of 2018, on 16th September 2022, the honorable court, the honorable division bench, permitted the petitioners to accept payment from the state / alleged contemner therein without prejudice to their rights and contentions. The petitioners seek reconsideration of their application for reference. Application for reference. Paragraph: upon consideration of the submission made on behalf of the parties and material on record, comma, this court is inclined to hold that since the award was accepted by the petitioners in terms of the order of this court, comma, the same cannot preclude them from filing a reference under section 64 of the Act of 2013. The second paragraph of the letter impugned, turning down the prayer of the petitioners on that score, is required to be set aside. Paragraph: in view of the above, comma, the second paragraph of the letter dated 3rd March 2023 is set aside / quashed. The concerned authority being the respondent number
P.
3. Third respondent herein is directed to revisit the issue
He set aside, my
upon-
lord, with commensurate lordship, page 112 and 113. 113 is that award, which has to be set aside for them to revisit.
I'll not set aside the award. I'll set aside only that paragraph of the letter and I'll send it for reconsideration.
The reference is before a higher forum, but that forum is absent today. Therefore, I don't have a remedy of reference because of absence of forum. Therefore, my lord, my learned senior friend also says, and my lord, in his usual fairness, that the award requires a reconsideration. Reconsideration by the same forum. Now, unless your lordship sets aside the earlier award, the reconsideration may not amount to anything. That is why, my lord, I am making this humble prayer. Had the reference authority been made available to me, my lord, I would have gone up before the higher authority. Please see, my lord, section
I'll
6.
ask the authority to reconsider the award without setting it aside. I cannot set aside the award like this.
Because
court
of the
cannot.
absence of the section 64 forum, my lord, subject to what
Let
also.
the authority decide.
Entire
Let the authority decide.
award.
My lord,
দুটো পড়বে যে এটাও এইটা সেটা করে রিকনসিডার
চৌষট্টি authority নেই, উপরে তো ওটা
সেই জন্য তো
blank।
রিকনসিডার দেওয়া
তাই ফোরামে পাঠালে তো ওটা set aside করে
হ্যাঁ।
পাঠাবে। Otherwise, not if he comes to a different conclusion, both will simultaneously coexist.
Revisit the issue of enhancement of the award. Let that be stated.
Enhancement, he can't make himself. He is functus officio now. Enhancement can be made by the higher authority, which is now not in seat.
Yes, so he has to consider.
So he has to
be considered.
Therefore, he has to consider the award. He has to pass a fresh award upon hearing us. Otherwise, enhancement is functus officio.
My lord, if your lordship pass the order, reconsider the award, then my lord, entire order will be
Set
reconsidered.
aside and reconsider the award.
Consider the award, your lordship.
Had
That is what I am saying, reconsider enhancement of the award.
Yes.
I am not setting aside the award.
Please bear with him, Lord. Please bear with me. He's an authority. He's already passed an award. Good, bad, indifferent. He's functus officio. My lord is directing it to be reconsidered. Now, if the parent award stays and his reconsideration gives rise to a separate thing, then both will simultaneously coexist.
No, not at all. He'll enhance the existing award. That's
Therefore,
all.
Lord, kindly provides for that.
He'll
Lord.
only enhance the existing.
Noted.
That's what I've stated. Reconsider enhancement of the existing award. That is what I cannot.
I am deeply obliged in whichever way.
কি বললাম বলুন? Yes, revisit the issue of enhancement of the award. As specifically stated, upon affording opportunity of hearing to the petitioners and pass a reasoned and speaking order within 2 months.
Yes.
Within 2 months from the date of communication of the order, comma, in accordance with law.
Only
Paragraph, copy of the enhanced award, comma, if any, comma, be communicated to the petitioners within a week thereof.
only one parameter.
Disposed of which.
Only one parameter. The petitioners shall be entitled to at the hearing to place appropriate documentary evidence in their support.
একটা line add করে দিন যেখানে in accordance with law বলে ওখানে the petitioners are at liberty to produce all documents,
That they wish to rely on.
produce all evidence, produce all evidence documents, all evidence hyphen oral and documentary, comma, before the authority at the time of hearing.
I'm deeply obliged.
My lord, item number 2, my lord, should not appear, my lord. Kindly, item number 2, my lord, I could not appear at the time of call, my lord.
There was someone and an order has been passed, sir. Please find out.
Item
Yes,
6.
next.
Oh. Petitioner এইদিকে এইদিকে জানা আমরা চেঞ্জ করতে পারছি at least today I think all the respondents are here because in so many occasions my lord they took
You
at
are appearing for the.
yes
I'm for mineral development, but Mr. Mitsu.
yes I
Mr.
inquired.
Mitchell's appearing.
Now, let me just explain in short this case, my lord, because twice earlier matter appeared before lordships, but was kind enough to pass a necessary order. But what is actually happened in this case, my lord? My lord, in 30th January 2017, the petitioner participated in the competitive biddings and a mining, my lord, for the mining operations, that was accepted. That was accepted. He was the highest bidder. Then, my lord, on 17th November 2017, the mining lease that was granted in favor of my client and the deed was executed. That was for 5 years. There is a specific clause of force majeure. Now, my lord, naturally, what is actually happened, my lord?
I think your issue is of road closure. The
Yes,
road was closed.
Yes, and
And
that
the
was
state
only
said
road.
that that was
Another
in
district.
connection with another district.
Yes.
And there is no other alternative route. That is from own records. Own record, own report. Let me finish, bhai. I appreciate their anxiety because they don't have any case. That's why they're excited.
Yes.
Kindly come to the, I'll not disturb your lordships, my lord. Kindly come to page. First, my lord. At page 68. What's the address? 68, my lord.
Mitru.
Everyone got it, my lord, page 68.
Yes.
On the left side, failure to fulfill the terms of the lease due to force majeure. So I need not do the entire thing. So there is a clause. Now, what is that which compel me to retreat for the time being? My lord, due to COVID, there is an order passed by the concerned authority that the road is damaged and no transportation should be made.
How can COVID damage a road, Mr. Banerjee?
My lord, for other reasons, my lord, I'm not going to the details. Very kindly, my lord, put these questions. Fact remains, road is damaged and transportation of heavy vehicles stop, which can be denied. It is their document.
So
I'll paste
post
it.
majeure clause is not applicable in your case.
Force majeure,
Yes.
100% applicable.
Have you taken the plea in your?
Yes. That is my case. Otherwise, there is no case. It is a force majeure
Your
because
case is closure of road.
my lord, that is why I placed that closer. Why? But they didn't allow me. I said that the force majeure clause will apply because road is not in a position to use. That is from their own record it appears. Kindly come to page 92, lordship first order. Page 92, lordship first order.
Yes.
Have you got it, my lord? Lordship order. Being the highest bidder, since that upon depositing the entire requisite amount. So before I started my business, I deposited the entire amount. The petitioners were granted long term is 5 years, but it is due to notification dated 25th March 2021, issued by the district magistrate collector, Purva Bardhaman, imposing restriction on movement of kinds of heavy loaded goods vehicles through the road leading to the mining block of the petitioners. Can you mark it, my lord? For which the petitioners were unable to continue mining operation till such and such, when by subsequent notification, the said restriction was withdrawn by the authority. So this is admitted fact, my lord. Kali marked in my lord. Learned counsel for the petitioners takes as quote the clause 5, part 9 of the deed of lease, which demonstrates petitioner takes this court to look such and such on the part of the lease to fulfill any of the terms of the condition of the lease shall not be the state government any claim against the lessee or be deemed a breach of this lease in so far as the failure to consider the state government to arise from force majeure. Can you mark it, my lord? In your lordship's order, in their presence order passed, my lord, consider this aspect. Force majeure and period of such shall be added to the petition. Then can you come to the next paragraph? In view of the above, my lord order. In view of the above, the petition is disposed of directly the second respondent to consider and dispose of the representation submitted by the petitioner within 6 weeks from the date of the communication of this order in terms of clause 5 rule 9. So this is a court's order. Nobody has challenged. After hearing both parties and looking to trading the deed of the lease as well as the notifications and such, after the accommodating out his own opportunity of hearing such and such. Then, my lord, after that, can they come to come page 96?
Yes.
Have you got it, my lord? Page 96. This is a letter issued by the district magistrate Bankura to the Assistant Secretary Government of West Bengal and the Chairman of West Bengal Mineral Development regarding representations and such and marketing private and such order number High Court. Due respect to your information, but I need not disturb the lawsuit by reading the internet. Next page. Next page. In this connection, it is to be stated here that as per said order, Honorable High Court Calcutta hearing was fixed on petitioners. After that hearing with the petitioners, it presumes that sand mining activities was genuinely affected from such and such due to the above notifications issued by the district magistrate Purva by such and such. The inability to carry out the mining operation is beyond the control of the lessee. It's a very vital aspect. Now, my lord, one very interesting thing is this, that well, after that, Kali come to next page. Page 98.
Yes.
My lord, skip this one. Kali come to page 100.
Yes.
100, page 100.
Yes.
After scrutinizing all the relevant documents, it is found that the long-term mining lease deed of petitioners was registered on Thursday, as well as on Thursday. Hence, the lease of the petitioner is valid till 20th November 2022. It may be presumed that in view of the notifications as issued by the district magistrate Purva Bardhaman regarding restriction of vehicle movement, sand mining activities of the petitioner was duly affected. I have noticed and such. Then, in addition, as far as West Bengal sand mining petitions are there, the state government has appointed the West Bengal Mineral Development and Training Corporation as designated agency for governing excavation, transportation, storage, sale, and consumption of sand. In the policy clearly mentioned, Schedule 6, that in existing lease, kindly marked existing lease, after the execution of the introduction of this particular document, of course, there is some confusion. Even if lease is executed, then the lease, the lessee shall not renew, lease shall be renewed and shall automatically be resumed and vested with the state government upon exercise of such lease. My case doesn't apply at all. Then, because my lease by this time expired, my case is completely different. Kindly come to next page. General provision 5, that they are no part of the lease fulfill any of the terms and conditions of the lease shall not keep
the state government is concerned, well, that is quoted, my lord. Then, in the light of above mentioned observation, it is not possible to further extend renewed. My lord, this is not a case of extension renewed. This is a force majeure is some sort of compensation that you are giving a power, giving a opportunity. My lease is expired. My lease is not executed after introduction of these particular rules, and no retrospective is given to that. The right to renew my lease petition. I am not asking for renewal. Not extend the petition as the undersigned is saying with the four corners of the statute. However, a letter may be issued to the Department of Industry, Commerce and Industry, West Bengal, by the requesting to consider the matter sympathetically as inability of the carry of the money operation yet beyond the control of the case. Very rightly it is stated. But unfortunately, it was not discussed about the effect of this, to give effect of this rules, if at all. Then kindly come to page. Last at page 108. 108, my lord.
Yes.
This is the order of the Assistant Secretary. Kindly skip over, my lord. Enter fact is narrated, then kindly come to 110. Have you got it, my lord? 110. Paragraph 10. Now, after careful consideration of the representation of the petitioner and the written argument stated above, the record available in this department, it is found that there was no restriction or exception of sand. The mine stated above for the period from such and such and such, and also the petitioner, that is the lessee, has got almost 9 months even after the withdrawal of the prohibited order on movement of heavy loaded vehicles. Is no answer, did not make any appeal to DM Bankura to allow him transport the sand in different routes. My lord, kindly come to page 42. I am reading, sir, page 42.
Yes.
You have already got it, my lord. First thing, my lord, page 42. 1. To enter upon land and search for wind, work, etc. Liberty and power at all times during the terms hereby demised to enter upon the said lands and to search for mines, bore, dig, drill, for wind, work, dress, process, convert, carry away. Because if I cannot carry, it is useless. To carry that sands, a road is needed. Now, if there is no other road, I've got no other alternative. Now, very peculiar stand is taken. After expiry of the lease, I got the 9 months. Why did you not do so? How can I? Then kindly come to next. Then page 89. They say I did not make any representation. Very unfortunate. 89.
Yes.
1, 2, 3, 4, 5, 6 from the bottom. Have you got it?
Yes.
It starts with the road being the only route for communication as per the mining plan granted. Kindly marked it, my lord. I cannot deviate from that. It is not my present desire. The Assistant Secretary did not care to consider the thing. He was totally biased. The road being the only route for communication as per the mining plan granted to me for sand extraction of dispatch going through the public bottom of the district. My lord, it has not never been denied. On the other hand, my lord is surprised to know that I have already page 96, my lord. Page 96.
Yes.
Beyond the control of the lessee. Page 96 and 97. This district magistrate Bankura.
Yes, he's
I've already placed.
Yes.
Then kindly come to my lord's order at page 105. My lord's second order. Have you got it, my lord?
Yes.
105. Heard the council. Pursuant to the order passed by this court, that the representation submitted by the petitioner was taken up for consideration by the district magistrate Mankura, who, while in our Sansad, forwarded the same to the Assistant Secretary to the Government of West Bengal, Department of Industry, Commerce and Sansad, consideration for sympathetic consideration of the representation, since, according to the district magistrate, he was not in a position to extend the lease period in view of the new sand mining operation policy. Very rightly he said. But confusion that has been created as this, it is not renewal as such. Totally confused, my lord. There's a clause in the deed that force majeure will apply. So just adjustment of that, not the renewal. I have lost 9 months, that to be adjusted. Totally wrong conceptions. Then, since the matter is pending before the Assistant Secretary to the Government of West Bengal, Department of Industry, Commerce and such, mining branch being such, the second respondent is directed to consider and dispose of the representation within 2 weeks from the date of condition. In the light, this is very relevant. Have you also got it, my lord? Very important. Communication of this order in the light of the observation made by this court in the order dated 19/22 in W and such upon appointing his opportunity. Kindly come to 1 second, page 92. 1 second. Please come 1 second. Page 92. What was the order? Page 92 at page 93, last but one paragraph. In view of the above, consciously my lord pointed out, look, I am directing you to dispose the matter with reference to my order, earlier order, and my observation. In view of the above, the petition is disposed of directing the second respondent to consider and dispose of the representation submitted by the petitioner within 6 weeks from the result in out of this order. In terms of clause 5, part 9 of the DWs, as well as the notifications and such. So only that notification has been taken care of, not the other thing. Kindly then come to page 108. 108.
Yes.
Now, irrelevant history that has been incorporated in the order, but the relevant part is 110. Have you lost in mind?
Yes.
110. Page 110, mind.
Yes.
Paragraph last but now, paragraph 10. Now, after careful consideration of the representation answer of the petitioner and the written argument stated above the record, it is found that there was no restriction on excavation of sand from the sand mines stated above for the period 25th March 2022. And also the petitioner that the lessee has got almost 9 months, even after withdrawal of the prohibited order on movement of heavy loaded vehicles issued by the DM and collectors and such. Neither did he make any prayer to DM Mankura to allow him transport to send a different route. How can I? Even the DVM cannot, DVM have no right to deviate from the terms. They are person themselves. What is talking about, my lord? It's totally biased. Did not make any prayer to DM Mankura to allow him transport sand in different route following the impositions and such. Kindly see, is there a different route? I'll place their own document. Again, kindly come to page 42. Page 42 once again.
Yes.
I defer liberty and power at top, page 42. Liberty and power at all times, the terms here based on such mind and such was carry away and this of the sun denotes. So it is an agreement, this is one of the parties you can carry out, but specified route, the route is damaged. It is my present and desire. Something more is there from the record I will produce. So this is the findings of the, is something unusual. Why he has considered my lord directions? Is there any indication? He is sitting over the order of your lordships. How he dared to say like this? I am really surprised. My lord indicated what is to be considered. They can come and say, my lord we will not consider for this is for modification or to paper an appeal, because there is nothing wrong in the appeal order. Now he is saying something which is contrary to the order of your lordships. What is that order? It is something unusual, dangerous. My lord says how and which manner to be prepared done, and he is saying something which has got relevance in no time. How is it? There is a limit of it. Now kindly see one affidavit. Because my lord directed, he must file a report in the form of an affidavit. First, my lord, which is affirmed by one Partho Pratim Vishwas, officer in charge law cells. He is the best person to confirm. Which is affidavit got it, my lord. Partho Pratim Vishwas. Kindly see.
Yes.
Then page 3, my lord, just above Roman II, as per petitioner, it is the only route of communication to the learned. Have you put in, my lord?
Yes.
Then the main givens of the petitioner is that due to the said restriction imposed by civil state and collector failed to continue his mining activities till his withdrawal, for which the district magistrate consult, according to the petitioner, this restriction of the vehicles comes under the provision of the first majorities. Accordingly, my lord directed to consider. Then, kindly come to the next page. Clause I. পড়িনি বলছিস নাকি? পড়বো পুরোটা পড়িনি বলছিস নাকি? ও তাই ভালো, আমি চেপে যাবো না কিছুই। আমার পেজ 4 I.
Yes.
আমার 1, 2, 3 মানে 3 line just above the Roman form. In terms of clause 5, have you got it, my lord? I. In terms of clause 5, part 9 of the deed of lease, as well as notification such, after affording reasonable opportunity of hearing, in compliance of the distribution conduct the hearing with such and such, on the basis of that hearing, the concert distribution being responsible, hearing issued a letter to the assistant secretary chairman with a request to consider pair such and such. Then these are all fact. Very interesting at page 6, which is very, very important. Page 6, Roman 9.
Yes.
Have you got it, Mike? It's very important. It is further stated that very recent, as per direction of the ADM, and Bankura, a physical survey has been conducted by M such and such non-technical over the sand mining area of the petition and found that there is no connecting route through which the sand-loaded vehicles can ply such and such connection. But I'm really shocking. It is shocking for me when there is physical verification by the government authority. The ADML thinks he's above everything. He says you could have used the alternative route. He's denying his own record, and there's without any further verification. Verification was made by physical inquiry. Now, here also the mining operation is mentioned, new rules mentioned. It is also respectfully submitted that as per the clause such and such, in existing leases, the lease shall not renew and shall automatically be resumed and vested with the state government upon expiry of such lease. The state government shall then lease and such. And all is further stated that the new mining lease operation, West Bengal Central Storage has been enacted, wherein no provision for extra renewal doesn't apply in one case. My lord, my lease was executed 17 November 2017. Kali marked it, my lord. Was there any existence of these notifications? Nothing. No retrospective is given. Only this cost, no increase it will apply in the existence of new lease. There is also fallacy. I'll come to that immediately. Now, here he also annexed all the orders. I need not disturb your lordship because it is already. Now kindly come to page 16 of this report.
Yes. So
Page
this is
6.
admitted.
Huh?
This is admitted.
Admitted.
There is no alternative route. Yes.
Yes. If that is so, then kindly come to another affidavit. It's very interesting. Chandrasekhar Rai. I'm really, there is what is going on.
Yes.
I'm sorry to say, fortunately, it was not done at the time when I was in a position to control all these things. Now it's about 23 July. Chandrasekhar Rai has got it, my lord. Kindly come to, some facts are there. Now, page 7. First, my lord, I'm sorry.
Paragraph 7. I think.
No, my lord, kindly page 5 first, my lord. I'm very sorry. Page 5. Page 5, my lord.
Yes.
Middle portion. Mining at 1, 2, 3, 4, 5, 6. 6, following manner. Mining is following manner. Sand mining means
Yes.
any or all activities undertaken for the purpose of mining river sand. Definition of the transportation of the sand has been defined. Rules such and such of the said rules in the following manner. Transport and transportations. Why this provision is included? Transport and transportation. I'm affected. I cannot, that includes the mining operation. That's what I'm saying. Then, crystal clear that sand mining has nothing to do with that. Kindly see, this is something funny. Means carrying sand one place to another, motorized vehicle or by head, such and such. From the aforesaid two definition, it is clear that the sand mining has nothing to do with the transportation of the sand. What is his designation? Maybe he's a big officer, as he thinks himself. He is Chandrasekhar. Chandrasekhar. I'm the assistant secretary. He quoted earlier part, transport and transportations. Then he says it has got nothing to do with the mining operations. I'm really surprised. Then kindly come to next page. Well, very interesting. I'm really page 5, paragraph 9. Have you got it, my lord?
Yes.
He's trying. I say that Golsiti Gokam Bhaya Same I have from the said block of petitioners, which is situated under Patusar police station, Bankura district. Moreover, the said road is not only the way which should be evident with the Google map. He's such a person, he didn't care to investigate, but district magistrate, my lord, inquired and found that is the only way. There is no alternative way. And that is on record, he has reported there. He filed this report. And seeing the Google map, well, I do not know computer, I do not know Google's map. He said, no, there is other routes. It's very expert. Then kindly come to, again is a paragraph 10. I say from the applicable statute governing sand mining, it would be evident beyond doubt, mining of sand has nothing to do with the transportation of the sands. But he's saying something is contrary to the record. He says something contrary to the lease, the mining lease. He says something with the rules. Mining operations include transport and transportations. Then I say 1, 2, 3, 4, 5, 6, 7, 8, 9. From bottom, I say that stopping of vehicular movement cannot have any effect the mining of sand. It might have affect the transport. More he said, more is in trouble. He says, yes, in transportation it is, again I'm reading. I say that stopping of vehicular movement cannot have any effect of mining or sand. It might affect the transportation. Kali is a river bed. If I stag in a particular place, it will be washed out. No problem. So immediately transportation should be made. That's why transportation is included. So they say he has nothing to do. So I'll excavate and again he'll go to the river. So everything is gone. What type of responsibility was suggestion? Even the petitioner could have asked, kindly see my lord, last 3 lines. Even the petitioner could have asked for alternative route for transportation of the sand, avoiding the gold sand. Who is there did not ask for that? He is asking, expecting, I'll deviate from the agreement unilaterally. If he knows minimum, I've got the idea of the law, unless unilaterally I cannot change terms. First carry out, transportation included. He is confused, he himself is confused. And then, my lord, He could have approached for different road. How can I? And from their own investigation is found, there is no other alternative route. So how can I? This is the way he dealt with. Then, paragraph 13. Paragraph 13, page 7. I say that from the facts disclosed herein above, it would be evident that the observations shown 3 are contrary to the admitted record. What is that admitted record? Google's or physical verification? It's an assistant secretary. Admitted record. And who has admitted? You said something, you are saying admitted somebody. Who has admitted? Did you disclose here? Only admission is Google's record. Therefore, the concerned respondent ought not to have made such observation. He is condemning his own officer's team. Kindly see in the report, only to save his own skin or to oblige some persons who is maybe pulling the thing, sitting there to oblige some other private party. I cannot prove there's a problem. Everything is going on nowadays like this. In this way, paragraph page 10, my knowledge and those who are made paragraph 2, 4, 2, 9 are information. Let us see what is paragraph 9. Now, paragraph 9, can you see?
Yes.
Paragraph 9, that Google's map. How it is happened? Information derived from the record. What is the record? Record speaks otherwise. It is not to my knowledge. Kindly see, cleverly he has done it. He knows that what is the consequence. He says information derived from the record. Google's in your pocket. That is the record. What you will rely? Your own record, government record, or the Google's? And this is in fact derived from record. Once you take the responsibility for record, you must bring the record that this is the record. Because record will speak otherwise. Physical verification will sit on all any other things. No Google's. So this is the way, my lord. Now kindly come to notification. Very interesting. At page 16, rules.
Page 16 of?
Page 16 of this affidavit. This great man, National Secretary, who is sitting over the order of your lordships. There's a direction how it is to be done.
The 21 rules, it is not applicable, the state will admit.
Not only that, there is another interesting. Of course, I do not know, my lord. They may satisfy. Sometimes rules, notification, act is published, but there one clause is there. Subsequently, by gazette notification, it will be. Kindly see, my lord. In exercise the powers, government should make the following rules. These rules will be called those sponsors. It is this shall come into force from the date of their publication official gazette. That gazette has not been annexed. What is that gazette? Official gazette? What is that? I've got some experience. I mean, misfortune on my part. I worked for them for several times, for at the 3.5 years. What is that gazette? He was showing something. No effort can be given to that unless you can prove that well by way of gazette notification effort has been given. And he is making the statement by an affidavit. Am I clear to you, lordships? Because I face the same problem. At one point of time, the corporation realized a huge amount of money in the form of drainage development fees.
This is the Gazette publication, 31st January 2022.
This is a Gazette publication regarding the rules, but effect to be given when further publication. Otherwise, there's the meaning. Otherwise, it has got no meaning. If it is really a Gazette publication of this rule, then why this made? These shall come into force from the date of one is published, other is to give effect to that. Because I face the same problem. Am I clear to your lordships, my lord? Well, if I'm wrong, kindly tell me so that I can clarify myself. One is today by Gazette rules is framed, but in there it is specifically mentioned. No. Merely because rule is framed does not mean that effect to be given on that day. Subsequently, by Gazette notification, from when effect to be given to be published. Again, I'm reading. This is shorter than this. They shall come. They means all. Have a look, got it, my lord. Once again. They means notification. They shall come into force from the date of their publication in the official gazette. Am I clear to your lordships, my lord? If I'm wrong, kindly tell me, my lord. I don't mind. That means Had there been intention of the legislature to give effect on that day, henceforth effect is given to that. There is no question of giving that that indication. No. We have published. Rules is published. But until unless by gazette notification effect is given, no effect can be given. There is one very case, that's the same case I faced with Honorable Justice Chief Justice and Justice Joyamala Bagchi. That notification is published. Joyamala Bagchi, then no, Justice Bagchi, no, Mr. Banerjee, show me. Yes. When it is given effect too. I say, consider, I'm sorry, my lord. But look, I'm giving time. Go and publish, give the gazette notifications. I'll not take any action. Very well. Where is that gazette notifications? So that means it is still, it is not, no effect can be given to that. But I say it just doesn't apply in my case. My case is completely different context. My case is this, that well, I am got it 2017, is the agreement between the parties. I was allowed to do the mining operations, no problem. And that is for 5 years. But I face a tremendous problem due to road conditions. I cannot carry out. Well, carry out is only the part of the state. Carry out is mentioned. I point out to my lord. So carry out. So I approach them. This is a situation, sir. Please help me. Because you on your own fasten yourself with a clause force majeure. Is it not a force majeure? They inquired, they found, yes, it is a force majeure. So that should they certified. They mentioned, they inquire. Then another, is there any other alternative route? They inquire physically. No, there is no other alternative. And this gentleman, the adjutant says, you got enough time. You could have, unless I get a permission, how can I? This is very funny thing. And that was not the direction of your lordship. I could have understood, my lord kept it open. My lord says what is to be done, what is not to be done. This is my order. Why my lord pass this order? I just do a lordship regarding on Supreme Court judgment. My lord can also pass this order. Yes, I am directing the judgment of yes, paragraph 1920. So my lord said, let us wait, let us see. So that's why my lord restricted to that. Consider this aspect. Can you sit over the lordship's order? I'm just asking myself. Even in our country, even the Prime Minister and others, Chief Minister, or any other officer cannot sit over the order of your lordship. Not your lordship means order of the High Court. If they are aggrieved, you can paper an appeal. You can ask for notification. But what is going on? Court will say something, he will proceed another day. And in Bengali, what is called Mongola. Google's Agadam Bagadam. What is this? This is really costing money. It is my stake. I am losing so many. And the most intelligent thing is my lord. Before I started this job, I deposited the entire money.
Yes, yes.
Then
that is not in dispute.
Nothing is disputed, except the commissioner's assistant secretary on his own created something which is contrary not to the record, their own record as well as order. That is why again I contact my lord. Remind your lord the judgment of Supreme Court that it is high time, my lord, to say no. Enough is enough. Twice I gave you opportunity. Your whole intention are not to do that. I am directing because I have that right and power. That is a Supreme Court judgment. Thank you. I'm grateful, my lord.
That's all your submission?
Yes. Okay.
Will you continue on the next day?
Next day.
Yes.
Today or next day?
Let them continue on the next day. Other matters are waiting.
I don't mind, but in this way they cannot depart because time they took adjournment.
Concluded your argument.
I'm concluded.
Yes, let the respondents make their arguments for the next day.
Very well.
Heard learned counsel for the petitioners. Paragraph, let the matter appear under the same heading for further consideration on.
এখনো কি আমার ক্লায়েন্টের জন্য চিন্তা হয় না করতে লাগে তুই তো আমার জুনিয়রের কাজ করেছিস তখন তো তুই
14th next week.
My lord,
14th.
As well as
Since I've heard it substantially, let it appear next week. We'll complete it on the next.
I'm good.
Your lordship.
It is a part of my lord. Now there's a part to keep it as a part.
Next week, sir.
Fixed or will not?
No.
14th.
14th September.
So next week. Yes.
Next. Lordship. Next.
May I leave, my lord?
Item 8.
I'm for the petition.
Item number 8.
Or this is my video service. Or this case has this checker history or not. What happened in this
Who is
case?
appearing for the respondents?
Also same matter, my last analogous matter.
এটা eight
Seven.
হচ্ছে।
Eight.
এটা eight,
Eight.
seven?
Both are analogous matter.
On prayer of the private respondents, the matter is adjourned. তার আগে affidavit of service. Let the matter appear under the same heading on 19th September.
19.
My lord.
My lord, ABDB service we kept on the
Nine.
Nine,
9 and 10, both, my lord. I am for the
Yes.
petitioner. My lord, sir, all parties have been served.
yeah, only the state is there, yes.
Let go.
Place your case, please.
My lord, land acquired for the purpose of Howrah Amta railway bridge. My lord, after acquisition, there was no compensation paid till date, but the award declared. Two notices were served upon the owner of the land after he passed away. He passed away in 2004. Notices were served after his death. I'll be showing the notices first and then the award. There are page 38 and 39.
Who is the petitioner?
Petitioner is the son of the deceased. The first notice was served on 17th of August 2004. And page 19 is the death certificate of the original owner, who died on 24th of April 2000. Now page 42 is the award.
42,
Page 42. The lordship will find
42, yes.
from the same plot, there are three owners. Two of the owners have already been paid by check number so and so. Page 42.
Yes.
And Satya Prasanna Khan, your lordship will find 2,09,064 not been paid. So he was the owner of the plot. Subsequently, my lord died and he gifted the property to his son. Deeds are already annexed. Now your lordship comes to page 44.
Yes.
My lord, point number, serial number 2 in LA case number 11, 2000 of 2002-3, 66 acre of land was acquired from Satya Prasanna Khan award serial number so and so. Total land was 1.98, out of which, my lord, 66 has been acquired. Decimals of land still remaining unidentified and undemarcated. In my case, is not award should be declared.
Award has been declared.
Declared, but no year.
Not paid.
Not paid, no amount has been transferred. Till date. So I am entitled under the fair compensation act according to present.
No. He can't.
Definitely not, as because if during last 5 years, if it is not paid and the award lapses, according to
My
the
lord,
act, section
I
12.
am permitted to file the
Report. Have you served a copy, Mr. Dev?
Now, I have to. Now. Now.
If that be so, let them file affidavit. Let it be decided on affidavits.
Why don't you go through the instructions and find out what the state has to say?
Lordship.
If you need some time to go through this, you can, because you've received a copy just now.
Just now it has been received, but I have to go through.
Please go through this. If you want to use an exception, you can do that. Affidavits will not be required in this matter. We'll dispose it.
Lordship. Then I have to.
क्या प्रोवाइड হয়েছে? As an executor happen.
Whether the will is not up till now provided.
Will is under probate, whether it is the executor, some is the executor,
Not yet probated,
not yet probated, under probate. Executor
so it's premature.
Executor has just done. They have to file a case. Under probate. Provisions is there. The right vested upon the executor.
Compensation has been paid to most of the awardees.
But they have not, they are saying that it has not been paid. Notices were issued on a dead man.
Most of the awardees were paid, the petitioner was not paid.
Other two
Yes,
owners
yes.
were paid. The paragraph 9 is said. Payment of award to the beginning of
Yes.
not be paid by this office.
But that is not in dispute, that it has not been paid, yes.
98টা দিয়ে দিয়েছি 93টা নাও একই ওটা তো দুটোই রাখো 93 মাই লর্ড দ্যাট ইজ এটাও রাখো এটা তো পাবে এটাও রাখো
Both the same cases, 9 and 10,
মাই লর্ড দ্যাট ইজ
only the.
আই হ্যাভ গিভেন দ্য নেক্সট মাই লর্ড দিদি একটু দেন না এটা
You have two prayers, one is payment of the compensation, secondly for
compensation.
demarcation of the,
In the second case, we have 37 decimals of land, we are still lying vacant, an adjacent plot of.
no, let us deal with the first case first.
মাই লর্ড ফার্স্ট কেস দ্যাট ইজ
In the first case,
2 decimals will not lie.
second case I have handed over the inspection in the second
oh, this is the first one, yes.
yes ma'am
But the report should be the same.
yes ma'am
So are you ready to receive the declared award?
Lord, I am not claiming.
My
that
lord, how
the
you
new act,
you will get
because
the-
my lord,
my lord,
they
have
have
you
not
got
paid. The act says, my lord, I am reading section 24. Kindly come to my lord, section 20.
Yes, come to section 24, please.
And I have brought judgments also.
Section 24, yes.
Land acquisition process under Act 1 of 1894 shall be deemed to have lapsed in certain cases. Whether no award, whether, that second D is whether an award under section 11 has been made, that such proceedings shall continue under the provisions of the said land acquisition, as the said act has not been repealed. 2 says notwithstanding anything contained in subsection 1. In case of land acquisition proceedings instituted under the Land Acquisition Act 1894, where an award under the said section 11 has been made 5 years or more prior to the commencement of this act, but the physical possession of the land has not been taken or the compensation has not been paid, the said proceedings shall be deemed to have been lapsed, and the appropriate government, if so chooses, shall initiate the proceedings of such land acquisition afresh in accordance with the provisions of this act.
Yes, when possession is not taken,
Two things,
Or-
Malad, 2 things arise.
it's or,
First,
either or.
I am in the second category, Malad, compensation not paid.
Either possession not taken or compensation. If any one of the things are done, then this is not applicable.
In my case, compensation not paid.
Admittedly, possession was taken
Possession was taken
So-
or compensation not paid.
or. So it is
Madam,
either or.
I am coming under 2, Malad, compensation not paid.
If possession is taken and compensation not paid, this is not
Kindly, I am
applicable.
reading once more, Malad.
Yes, please, please.
For
This
my
is settled law now.
settled law.
Both have to be affected actually. Possession should not be taken,
No, in
compensation
case
and
of
not
land
paid.
acquisition, I'm coming to that portion, my lord, where an award under the said section 11 has been made.
Yes,
Here award has been made. 5 years or more. But I already 5 years.
yes.
To the commencement of this act, but the physical possession of the land has not been taken. My lord, here physical possession has been taken. Or the compensation has not been paid, the said proceedings shall be deemed to have been lapsed. But I am coming under, compensation has been not paid. We have
The,
not paid the compensation.
the Supreme Court has made it very clear. The statute is also very clear on this.
But
If
I am-
both possession is not taken and compensation is not paid, you're entitled. If one of the
but I am-
limbs has been
but I have written.
2000, please come. The Indo Development Authority judgment is the latest judgment, which has taken into consideration all these judgments and has found
Where and how it should be done. What are the factors? Well, I have made an elaborate representation.
I'm sorry, you're not entitled to the 2013 Act. Sir, I'm sorry. You can collect the compensation that is due. That is due and payable by the authority. 2013 Act is not applicable in this case. I'll pass an order.
But let you count, let it.
Yes, you can if you want to. Definitely you can. Please come back. It is either or. So they let him come back with the. This is no longer res integra. Yes, please come back.
And we are trying to protect my balance area of land. That is lying undivided.
Nothing is being done with that land. It is lying.
That is unidentified and can't do.
So there's no, the state authority will not demarcate your land. They'll demarcate the acquired portion.
Otherwise, not the adjacent problem that you're making construction.
That is a private dispute, sir.
I know.
So how can the writ court pass an order of status quo?
Pass an order of status quo.
Not- Cannot. How? Because it is your private land and being encroached upon by private parties.
State authorities have not rectified the record of right. You see,
That is again under section 50, you have to apply before the appropriate authority.
have not rectified it.
You have to approach the appropriate authority for it. Status report submitted on behalf of the state respondents is taken on record. Paragraph. A learned counsel for the petitioner seeks accommodation. Paragraph, let the matter appear under the same heading on 28th September. 10 of affidavit of service. It should the affidavit of service 9.
28.
10 status report.
Oh, sorry. Hold up. Service stuff.
Next. Item 11. Yes.
11, my lord, in this matter, my lord, I
I'm for the state respondents. I'm for the state to state. Private respondents.
just let me see, my lord, once, sir. Two delivers, my lord, out of the rest.
Only 2 delivered.
Yes, my lord.
So please come back.
This is a filling up water body, a government water body.
Servant, come back, please. Sit.
Yes, rest of the private respondent, my lord, the
Who
response.
are
Yes, my lord, that I am indicating, my lord.
some of the ones who are not served. Since service upon all the private
Let me make
respondents
it.
is not complete. Paragraph, let the matter stand over till 3rd October.
Yes, your lordship. Yes.
Item 12.
Have some.
কোথা থেকে নিচ্ছি?
আমি নিলাম তোমার
Service complete.
Yes, only state one.
Mr. De, may I request?
Land of the petitioner was requisition under Act 2 of 1948. Thereafter, scheme has been abandoned. Petitioner earlier filed a writ petition. Your lordship directed to consider the representation. In considering the representation, they released our land. And thereafter, so far, payment of requisition damage compensation are concerned. I made an RTA application. They replied that fund has been sought for. Unless the requiring body places the fund, we cannot make payment. Thereafter, I made a demand. In spite of that, the requiring body is sitting tight over there. In an identical matter, your lordship was order on page 38.
The land has been released.
Yes.
Requiring body place the
Fund, yes.
place the fund.
Requiring body has to place the fund, in fact. Yes.
A similar issue, your lordship directed. Page 38.
This is also Mundeshwari.
Yes, same,
embankment.
same.
My landed pen is a Mundeshwari specialist.
Please, yes.
My landed pen is a Mundeshwari specialist.
Where is the order?
Page 38.
No, the order of the authority, where they say that you're entitled to
Yes, madam.
requisition compensation.
The reason order I have not read. They have
Yes,
released
the
the
reason
land.
order.
Madam. Kindly.
According to the provision, my lord, you will get.
Page 25 is the release order.
Page
25. And madam, page 30. Yes, page 30, my lord. Page 31.
And the earlier order of the court.
Yes, madam. Page 23. And madam, kindly see my page 31 once.
The second respondent should place funds.
Same respondent. No. Respondent of 6 will place the fund and payment will be made by the treasurer 2.
Placement of fund made by the second to the 6th here.
Requiring body is not the second part.
6th respondent.
Calculated amount of rate compensation.
Who is the requiring body here?
Respondent number 6, my lord.
The principal secretary,
Yes,
Governor
ma'am.
Westport.
Yes, ma'am.
He will place the funds.
Yes. Principal secretary.
Please make over a,
Sampurna.
please give a copy of the writ petition to Mr. De.
Yes, ma'am.
আমরা ওকে চেয়েছি তো
How can the principal secretary, irrigation and waterworks department?
Yes.
yes my lord
That is the requiring
Yes,
body.
yes.
yes my lord he will get the
Kindly see my lord, page 31 once.
We have calculated the rent compensation. My lord.
Fund one thing.
And now, my lord, his duty to place the fund.
There should be some correction. May I place the correction date of order?
Yes, yes, there should be some correct. Yes, I wanted to dictate it. Right?
My lord, today.
Change. You. order লেখা থাকবে না?
This paragraph also has to be the fund made by the sixth respondent to the second.
Yes, yes,
Here
same,
it is,
same.
here it is opposite.
No.
Please see the order.
That will be the procedure. That is, everybody will place the fund to the.
Sixth respondent will place the fund.
Please check this part. You have a copy?
Yes, yes.
Please see the second page, paragraph 3.
Yes, request made by the second respondent, my lord.
Yes, ma'am.
This is a request made by the second respondent.
We have already request, my lord, to now.
That has made, that
Yes,
has been
yes,
made.
ma'am.
also. Wait, let the same order be.
Yes,
passed.
yes.
Date গুলো চেঞ্জ করা আছে এখানে, এইটা করবেন, এই অর্ডারটা পাস করুন। ঠিক আছে? ওটা এখন করে দিন। Affidavit of service, none appears for the state respondents. So this appointment, regularize করে তারপরে এটা করুন। যেটা ওটা না, যেটা দিলাম এক্ষুনি আপনাকে, কারেক্টেড এক্ষুনি দিলাম যেটা। হ্যাঁ। Yes, next. Next matter.
Next one is similar, my lord. And I am filing the affidavit of service and change.
13. No one for the state. Mr. Dey, I request you to appear in this matter also. Same issue?
Yes.
Yes, ma'am.
Affidavit of service, Mr. Dey appointment regularize করুন। আর এই যে order এখানে।
Subject.
Fourteen.
My lord, in item number 14, I appear for the respondent, my lord. Perhaps this has to go, this particular writ petition has to go before the residuary bench. It is a matter,
I am praying for a short passover, Lordship. Passover is not possible in this.
it is a matter whereby a tender process has been challenged. So, my lord,
Yes, so this court will not be having determination.
Exactly. Lordship, there is a, actually, I am not ready with this matter. I am not ready with this matter today, Lordship.
my lord, I'll just give a
Not
very
satisfied
short
with my
background. What
preparation,
is this matter? Because, my lord, this court perhaps not have the determination.
Lordship, this is a hoarding issue, Lordship, the tender issue.
So tender issues are not dealt with by this court. It has to go under group 9, isn't it?
Lordship,
So I'll release the matter.
Lordship, I take a instruction from my senior, Lordship. Kindly
What
put a
further
very short
instructions do you
password.
want? What further instructions do you
Shall
need?
we determination mean this?
You are also aware that it will appear before group 9,
Lordship,
isn't it? Let it be released. Why do you want to waste more time?
Lordship, do you want me to mention?
Yes,
Do you want me to mention that?
that is automatically there. I don't need to record that. It is submitted on behalf of the respondents that the matter pertains to group 9 of the classification list. Paragraph, the matter is released due to lack of determination.
Lordship, as per the instruction of my senior, Lordship. Lordship, please.
Tender process, group 9.
Lordship, this is
tender, maybe tender process, but regarding this land of the KMDA.
Maybe, but it's a tender process. which
Lordship,
is- which
this is
the subject
not,
matter.
this is absolute not a tender process. Kindly come to the order that directed me to deposit straightway deposit the fund.
Yes, that is in connection with the tender.
No tender has been conducted. Kindly come page 58.
Yes.
In reference to your application dated 29 November 22, it is to inform you that the appropriate authority KMDA has approved your appeal for installation of hoarding around CTC Park, consuming area 1,000 square feet. The department has fixed an amount 8,85,000 at one-time basis for the period of 1 year from the date of deposit of the debt to prepare the agreement. You are directed to deposit 8,85,000 such and such for further necessary agreement and others. So immediately I deposited the fund, page 59. So there is no tender, straightway demand. I deposited. Now I repeated occasion, Lordship, the submitted representation for executing the agreement. Because this is a valid for 1 year. They have accepted my money. Lordship, I read petition filed on 14 June 23. I effected service on 15, 27, they have rejected.
It's not a land matter. How will this court deal with it?
Lordship, land, obviously land matter, because on the space, I have installed a hoarding. This is the
Either an acquisition not pertaining to a lease. It doesn't, it's not covered under
it's the
Group 1.
KMDA land. Lordship, they have asked me.
Find out Group 1 classification matters, sir. It is not covered.
Lordship, kindly appreciate. This is the land. This is the land belongs to KMDA. KMDA issued the demand notice. The demand notice for installation of hoarding in the land. This is particular KMDA is interested in the
Anything pertaining to the land will not be dealt with by this court, isn't it? If
But-
there's a murder on KMDA's land, it doesn't become a land matter.
that is
It's exactly like that. So please go before the appropriate forum without wasting further time. Only because it's KMDA's land, this court cannot deal with it.
now the KMDA is earning money utilizing this land. Lordship, kindly visualize in such a way. Because
Please make
KMDA
your-
has
If you really want to spend more time on this, please satisfy this court on the ground of jurisdiction of this court.
I subject your lordship's consideration.
I am praying for dismissal of this writ petition in that event. Because they have completely, it's a wrong initial stage. I very fairly submitted that my learned friend should go. This is an issue arising out of a contract, then a tender. How
There
come
is no tender. Also, I have produced the document. There is no
There
tender.
is no tender. The dispute is not with regard to land. Dispute is with regard to the contract.
Lordship, the contract, but you utilizing the land. KMDA is
Giving you an example. The dispute is the contract, not the land. There is no
Lordship-
land dispute.
Lordship, may I, Lordship, though Lordship, I am not correct, but may I? Lordship, the land has been utilized for installation of the hoarding. Lordship, they have given me the land for installation of
That's
hoarding.
a
Now they
incorrect
are,
submission. Land was never given.
yes.
Kindly come to
yes,
my
yes,
lord.
land and space has been
Oh. Kindly, though it's not, kindly come to page 38, 2016. It clearly talks about a contract that in a CSTC bus stop, one hoarding. How come my learned friend is saying that the
Yes, I
KMDA
have
has given
installed,
the-
I have utilized your land and
Be that as it may,
installation
arising
of the
out of
hoarding.
a contract, there is a contractual dispute. My learned friend has to go before the appropriate bench.
It's prayer for renewal of a contract, yes.
Exactly.
I'm sorry, Mr. Mukherjee.
No, Lordship, kindly come
I'm
page
releasing
58. Lordship, so far the tender is concerned, there is no tender. Lordship, it appears from page
There is a
58.
contract, there is no
Correct.
tender. You've asked for renewal of the contract. That's the first line of page 38.
Page 58. Lordship, kindly come
Renewal
page
of
58.
contract for Display of advertisement on
Lordship,
hoarding.
page 38 is the earlier basis. Now they have accepted page 58. This is the current. They have issued the demand. Kindly come page 58.
It's on the basis of 38.
No. Page 38 has gone lapse. Lordship, I have annexed those documents because I have an experience of working
Lordship, regarding hoarding, kindly confirm 58.
Installation of hoarding will
Hoarding-
not be a subject matter before this court. Released.
Grateful.
Lordship, affidavit, supplementary affidavit kept with the record.
Supplementary affidavit.
Because
Yes, my
they
learned
have,
friend- I have
after
studied it, so my learned friend has filed a supplementary served on me.
Amlan,
I mean,
supplementary affidavit submitted on behalf of the petitioner is taken on record. তারপরে ওই যে আছে।
because they have, after receiving the writ petition, they have cancelled my demand.
It's taken
notice.
on.
That is the.
Taken on. I'm sorry.
grateful.
Next.
Let's say affidavit of service of the captain.
Amlan, affidavit of service and supplementary affidavit submitted on behalf of the petitioner are taken on record.
15.
Affidavit service must state at all the state respondent mode.
You are for the?
I'm for the petitioner.
It's suitable for the state, yes.
Here, annexure P4 manner, there is a specific,
Have you served the,
all are
all
sir,
are state?
all are state. Ma'am.
Yes.
Page 22, annexure P4 manner specified that there is a acquisition of proceeding was there.
Page?
Page 22, annexure P4. The information from the collector that land has been acquired, but compensation amount has not been disbursed. On that issue, annexure P5, page 23, representation was made.
P5 is page 22. That is your representation.
Just before that, previous page. Information is there, ma'am. অধিগ্রহণ ক্ষতিপূরণের টাকা আদিত্য কুমার সূত্রধর ও আরো 4 জনের নামে ধার্য করা হয়েছে। That has not been disbursed, madam. Then manner representation was made. Page 23.
Aditya Sutrodhar is the predecessor.
Predecessor. Page 23, annexure P5, I have made representation upon the authority concerned, but till date, no compensation money has been disbursed manner along with interest manner. That should be disbursed, but this is my earnest prayer.
But they have submitted representative payment for compensation under Act 2013, my lord. That is not possible because of the fact, my lord, the land has been acquired under Act 2 of 1914. But if the land is not acquired under Act 1, the payment of under Act 30 is not comes. They have to have a possession hand.
Why don't you consider the representation?
Yes, ma'am.
But the, so far the Act 13 is concerned, that is not applicable. That kindly mentioned, my lord.
I will,
Act 13 is not, my lord. Payment notice has also been issued. They have received. And the father of the petitioner has received the compensation money, my lord. Father is one of the awardee.
No.
Yes, my lord. No, my record shows, my lord.
Information দেখো।
do you have instructions?
Yes, lord. I have received instruction of it. Can't you see my instruction? Page 2 is my instruction.
Copy আছে?
Page
Have you
1.
received a copy of the instructions?
No, nothing.
Please give him a copy.
Simple করে দিচ্ছি, বলা আছে।
Where is it stated that the father of the petitioner has received the amount?
Kindly see, my lord, well, page 2. Page 2, my lord, Aditya Kumar Sutrodhar. Aditya Kumar Sutrodhar is the father of the petitioner number 1. He
Yes.
has received, my lord, the compensation amount by check number such and such 21 of 11.
There is the document.
My document, kindly see page, my lord, 13.
Page?
13 of my report, my lord.
13.
Yes, my lord.
রিপোর্ট দিয়েছে আমাদেরকে।
Reports shows of my- My lord,
My report has not been given, madam.
the report, all the annexes is not in the report. If your lordship directs me to file the report in the form of unit, I shall file. my
Yes, because you say that compensation
sir.
has been paid.
lord. Yes,
If compensation has
My
been
information is that, my lord, the compensation money is not been ধার্য করা হয়েছে। But it is that's
one
report
of the awardee is the
12
father of the
to
petitioner number 1.
12 to
He has received.
2023. So on that basis,
And
my lord,
other, so far other petitioners are concerned, my lord, the awarded money is lying with the my lord, authority. If they approach with the authority will, my lord, and disclose their ownership, my lord, substantial.
Either manner, they have to dispose of the representation by stating all the facts. That should be.
I think that will be better
Yes,
because
madam.
others have not been paid. So
It's
why
not
don't
been
you
paid.
consider
Exactly.
the representation,
Yes.
hear them and dispose it off?
Only my Act 13 is not, kindly mention this.
I'll record your submission.
Yes.
Affidavit of service. Written instructions submitted on behalf of the respondents is taken on record. Paragraph, it is submitted on behalf of the petitioners that the land of the petitioners was acquired by the respondents The LA proceeding is 12 of 1991-92.
Yes.
Vide LA case number 12 of 1991-1992. Stop.
Under Act 2.
Though
LA case under Act 2 of
this
1940.
is the petitioner's submission. In reply to an application made by the petitioners under the Right to Information Act 2005, the petitioners were informed that award was determined in favor of their predecessors in interest. Stop. The petitioners submitted a representation before the concerned authority on April 15. The date is
Yes,
not
ma'am.
legible. On 15th April 2023.
15 May, my lord. 15/5.
15th May, yes, 15th May 2023. Seeking compensation under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Stop. The representation is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest and take necessary steps for payment of compensation in their favor in terms of the Act of 2013. Paragraph, placing reliance on the written instructions submitted on behalf of the respondents, learned counsel for the respondents submits that compensation has been paid to the predecessor in interest of petition of the first petitioner by check, and compensation declared in favor of the predecessors in interest of the other petitioners.
That is in the name of the petitioner.
Yes.
Other petition, they are the petitioners. First is the father of the petitioner.
The others are petitioners.
Others are the
And compensation declared in favor of the petitioners, in favor of the other petitioners is lying with the authority and may be collected by the petitioners. Stop. Learned counsel further, yes.
After substance, they are right, madam.
Yeah, may be collected by the petitioners upon substantiating their right in respect of the same. Stop. Learned counsel further submits that the present case was initiated under Act 2, Roman 2 of 1948, and therefore the Act of 2013 is not applicable herein. Paragraph, be that as it may, since the representation submitted by the petitioners is pending before the authority, the writ petition is disposed of, directing the Special Land Acquisition Officer, the fourth respondent, to consider and dispose of the representation within submitted petition is pending before the authority. Dispose of the representation within 1 month.
6 weeks.
Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, in accordance with law. Paragraph, the petitioners are at liberty to place all relevant documents before the concerned authority at the time of hearing to substantiate their respective claims. Paragraph, in the event the petitioners are found entitled to compensation, comma, such compensation be disbursed in their favor within a month thereafter. Disposed of which actually.
If possible, along with interest.
Yes.
If possible, along with interest, that should be.
They are entering.
Long.
You have not collected the compensation. Next. Next. 16.
16 now. What about the fixed matter?
Cool.
Oh,
Mention matters.
248.
I am for the petitioner, my lord. First, my lord, before I start, I am tendering my apology because I could not serve to the respondent fully. There are 16 respondents, my lord. Kindly 60. Kindly,
You need some more time to serve.
yes.
Will you come back after vacation?
No, my lord, only 1 week time. I am paying only 1 week.
Since service upon the respondents is not complete. Comma. Let the matter stand over till 3rd October.
My.
Two 49.
249, I am for the petitioner, my lord. My learned senior is also.
My lord, I'm for the respondent. I'm seeking for a days accommodation, my lord.
Lordship, I am appealing for the petitioners, your lordship. I am appealing for the petitioner, your lordship.
Wait, sir, I think there's a specially fixed matter at 12:30.
49, 12:30.
Lordship, I am appearing in 249, your lord. 249. Item number
49, fixed at 12:30.
There's a specially fixed matter at 12:30. Let me take up.
I am for the petitioner, my lord. He is my learned senior, my lord.
49.
He is my learned. 249.
For the 49.
49, fixed at 12:30.
Lord, I appear for this.
Matter, matter. For the 49.
49.
249. 249.
The specially fixed
49
matter.
special fixed I just have.
49 is a specially fixed matter.
No, no.
49.
49. 249.
249 না শুধু 40
পরে হবে 249 পরে হবে বলে
12:30.
Mr. Siddiqui was appearing for the state, isn't it?
Mr. Siddiqui, yes.
Now, where is he?
I tell your lordship, my lord, in this matter, my lord, the land belongs to the KMD and lease was granted in
He
favor of
has
the.
finished. Yes, now today is my turn.
Siddiqui presence is not.
Oh,
required.
no, no. He is,
Don't
we are
tell
the
me
principal.
otherwise. I am not.
We are the principal respondent. State's presence, no doubt. State is a.
His presence is necessary. No, his junior is
But-
also not there.
But if your lordship so pleases me, lord, I can place my argument.
No, but then Mr. Siddiqui has to, maybe has to reply or something.
State is a formal party here. I should
But
say.
he has
As
made
a-
elaborate submissions. The state has made submissions on the earlier date, isn't it? I find submissions made by the respondents.
No material submission was made,
No material submission was.
no
made.
material submissions.
Land conveyed to KMDA permanent.
It is the action of the KMDA is under check.
I understand, but then the state has been a party all throughout.
I cannot, But I am ready, my lord.
This matter.
I know it is not being taken up at all.
Or can we do one thing, my lord, subject to my learned friend has finished.
Yes.
Let me continue today. If I cannot,
The state will come and say, I have not heard what the KMDA has said. The court cannot do that, isn't it? It's difficult. Only even if his
In
junior
their
would have
presen-
been there, I would have.
Well, in their presence, my lord, the date was fixed, my lord. And this is not the first time, my lord. This matter is
The earlier occasion also the state was not there. Since it was adjourned on prayer of the
My
KMD,
lord.
he did not bother.
yes.
But the state was not there.
That is why, my lord, at my instance, the matter was adjourned till date. And I have come ready.
And earlier at the state's instance also it was adjourned.
But one thing, my lord,
Inform Mr. Siddiqui and request.
well,
him
I
to
will give
present.
reply. Let my learned friend, my lord, complete submission, my lord. In that even on the next date, my lord, the state will, my lord, if make
The state says it has been heard behind my back. Cannot be heard behind his back. Please request him to be present or send a learned junior office so that the matter can be taken up.
Junior কে পাঠানো একটু সিদ্দিকীকে খবর দিলে কেউ আসবে
Because his junior friend is also not there, I think, today.
Can I inform his office?
Please do that. Let me call other matters.
My lord.
Mr. Siddiqui আসুন, তো অনেকটা শোনা হয়।
Well, I have committed a great mistake because my junior was there. She could not tell my lord, my your lordship dispose of the writ petition. First day we appear for the state petition and did not appear. Your lordship make not to.
Matter.
Item number 12, Mr. They has been
49.
appointed. If we can be appear as his junior, my lord, because we have been engaged by the state and she is new one.
Give your name.
That is something I'm
249.
My lord, I beg to appear for the petitioners, your lordship.
This is Koto. 249, yes.
My lord. Affidavit of service, I am submitting, my lord. Affidavit of service.
Lordship, service upon all the respondents is complete.
You are appearing for?
Respondents.
Only consider the representation.
That's all the respondents.
All the private respondents. Why do you seek accommodation?
Because my lord, the advocate was not in town. It was his for some personal grounds or something.
Who is not in town?
Mr. Soibal, the
You are senior?
yes.
Lordship,
Be urgent.
Only consider the representation, my lord.
Yes.
Because I'm not
Only consider the representation.
my lord, the matter relates to removal of illegal and unauthorized construction from PWD land. The petitioners made representation before the respondent of state authority. We are before your lordship only for a direction upon the respondent state authority to consider our representation. That's all, your lordship.
Representation be considered. I'm not on merits.
That I'm not.
Only representation is required to be done.
Highly grateful, man.
Not today. Not today.
My lord.
Very short matter can be disposed of.
My
Grateful.
Next. It is written. $250.
I have to on behalf of the petitioner, madam.
Only state respondents?
The private respondent is there, but they are not necessary party, my lord. The fact of the case is that, my lord,
Have you served the private respondents?
I served, my lord, but the track report is not available, my lord.
So then you have to serve and come back.
They are not the affected parties.
Will you expunge their names?
Yes, no, I explain their name.
Yes?
I explain their name, madam.
They are not necessary parties?
No, madam. They are not
Why have you imputed them?
Well, they are just intended purchaser of the land, my lord. See the scheduled caste land, my lord, without scheduled caste land, without
So
the
they will be
permission.
affected by the result of the writ petition? If they are intending purchasers, they will be affected by the result of the writ petition? So they are interested, they are proper parties?
My lord,
Yes?
I will
Serve and come back.
kindly give us short day, madam. Petition
Since
is-
service upon all the respondents is not complete, let the matter stand over till 29th September.
Ma'am.
Two 51.
So by appear on behalf of the private respondents, 6 to 8.
Petitioner. Who is appearing for the petitioner? After vacation. These are all mentioned matters. If the petitioner is not ready, I cannot help.
Lordship, in any event, I have a point of maintainability since the order is appealable, but your Lordship, since the petitioner is not here, I can't press.
None appears for the petitioner. Paragraph, let the matter appear under the same heading on 5th October.
Grateful, your Lordship.
Oh, under the heading group 1 motion. Group 1 motion. হ্যাঁ মেশিন গুলো সব তাই করবে আমার
Grateful, your Lordship.
252.
For the petitioner,
Statement.
my lord, during pendency of the writ petition, my lord, my prayer before the special land acquisition collector that my grandfather, my lord, got the compensation amount. I am entitled to get the land loser certificate. Accordingly, I made prayer to the authority. After filing the writ petition and getting the service, my lord, the authority, my lord, passed an order, my lord, stating that inter alia, being a my lord, grandson, I am not entitled to get the certificate of land loser. So, my lord, either I have to, my lord, challenge this, my lord, this order by way of supplementary affidavit, or, my lord, I have to file a fresh writ petition.
You have to file, it's a fresh cause.
I will fresh cause of works. Let
this writ petition be disposed of.
dispose of with a, my lord, liberty to challenge the order, subsequent order.
The petitioner
Today,
prayed for issuance of land loser certificate in his favor by the concerned authority. It is submitted on behalf of the petitioner that during pendency of the writ petition, the petitioner's prayer was considered and turned down by the authority. On the ground that the petitioner, being the grandson of the land loser, is not eligible for enrollment under the exempted category as land loser. Paragraph, the petitioner seeks to challenge the said order in accordance with law. Paragraph, in view of the above, nothing further remains to be adjudicated in the present writ petition, and the same is accordingly disposed of. Urgent certified website.
next also same, similar.
Same thing. You
Same.
can challenge.
এটা রেখে দিন
253, same order.
same order.
For the state. Similar.
তোর কাজটা আমি করে দিলাম I have taken the burden of just now, my lord, I got it and I get it Xerox, my lord, print it out, and my lord, because there should not be any separation.
Not only you.
Just I got
without
it.
wasting further time, you can
Yes,
prefer an
yes,
appeal
yes,
or.
yes.
254.
Grateful, ma'am.
Yes.
254, your lordship, I am for the petition. Affidavit of service.
You served.
Yes, your lordship. It is the-
There are several private respondents. Have you served all of them?
Yes, your lordship.
Anyone appearing for the private respondents?
Representation,
Give me a minute, please.
yes, your lordship.
State? Appearing for the state? Mr. De, may I request? Please serve a copy of the writ petition to Mr. De. Yes, what is the matter about?
Matter is, the private respondent have raised unauthorized construction upon the PWD land situated at the western side junction, para 7 on page 7, Your Lordship.
Yes.
Para 7 and page 7. Para 6 relates to my ownership. Para 7, that private respondent had raised unauthorized construction at the western side junction of Surendranath Pur bus stand beside the Debogram road, which has infringed the petitioner's right to enter into his plot of land. Ground situation is on page 20, 21, 22. I have annexed also a map on page 23.
Yes.
And for the sake of such unauthorized construction, I have made a representation dated 15th May 2023, annexed on page number 24, Your Lordship.
This has not been considered as yet.
This has not been considered yet. And their construction has already raised, and on the several occasions I have raised the concern before the competent authorities, but they are not taking any steps to remove or initiate any proceeding.
Considered within a stipulated time frame. Let your representation be considered by the authority within a stipulated time frame.
In the time.
Right?
Yes, Lordship.
Mr. De. Period of service. None of the private respondents despite service. Mr. Their appointment regularized for copy service direction. Paragraph. Recorded owner. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD land adjoining his plot, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard for the concerned authority on 15th May 2023. Which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Four.
Assistant
Submitted
engineer.
on behalf of the state respondents that the fourth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months, since proceeding has to be initiated. Within 3 months from the date of communication of this order, within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law.
The copy may also be supplied.
It's an appealable, it will be an appealable outcome. It's not necessary. You will be called for evidence.
Grateful, Your
That is junior of Mr. Siddiqui Hazard. My lord, Mr. Siddiqui is on legs before court room number 5, and the junior in this matter is not in the panel currently. I'm his chamber junior. So let KMD start. I'll be there. I'll
Let
note it
KMD
out.
start?
Yes, yes.
Very good. 49. Let us go back to 49.
May I precisely?
Take some time.
Yes. Take some time.
Very well, other matters released for the first of matters, group 1 and group 2. Not all the matters.
My lord, may I precisely state the facts? Pursuant to the request made by the petitioner,
The petitioner was offered a bulk plot of land under the institutional category, measuring about 10 katas of land, my lord, being plot number so and so, under the East Calcutta Area Development Project, under certain terms and conditions. The petitioner herein accepted that terms, accepted that allotment. And thereafter, on 4th, this allotment was made, my lord, on 23rd November 2010. Page 34 is the allotment letter. That after fulfillment of the conditions so far the payment is concerned, my lord, the possession was delivered in favor of the allottee on 4th May 2012. Thereafter, my lord, on 27th July 2012, these dates are important, my lord. The possession certificate is at page 40. I'm not placing that.
Yes.
On 27th July 2012, a lease deed was executed by and between the parties, stipulating the terms and conditions by which such allotment would govern.
27 July 2012.
12.
Yes.
This is at page 41.
Yes.
May I invite your lordships kind attention to the lease deed. This is at page, starts from page 41.
Yes.
Kindly come to, amongst all of the terms and conditions, it was stipulated at page 51, 2.5. Upon execution of the lease, this lease deed or the lease agreement, the contract is concluded. The parties are bound by the terms of the contract being the terms of the lease deed. My lord, may I place 2.5 clause 2.5 at page 51.
Yes.
To commence construction of the proposed building within 24 months from the date of execution of this deed of lease, handing over of possession or handing over of possession, whichever is earlier, and to complete construction and commission of the healthcare related institute proposed to be set up on the demised premises within a period of 36 months from the date of execution of this lease, deed of lease. My lord, here, pausing here for a moment. My lord, here stipulation is within 24 months, the allottee has to commence construction from the date of execution of the lease deed or the date of handing over of possession, whichever is earlier. Let us take the date of execution of the lease deed itself. And to complete the construction by setting up the healthcare issue for which the allotment was made within 36 months from the date of execution of the lease deed. Next part is very vital. Provided, however, that the authority may, at its discretion, on an application being made, my lord, I am emphasizing on this, that on an application being made to it by the lessee and on payment of such fees or penalty by whatever name called as may be fixed by the authority from time to time, grant to the lessee such extension of time to commence and or complete and commission the project on the demised premises for such period as the authority may determine. Provided, however, that upon failure of the lessee to comply with the covenant to set up, complete construction and commission the project within the time originally fixed or as may be extended by the authority, the lease of the lessee shall be liable to be terminated by the authority, and the authority shall be entitled to re-enter into and or upon the demised premises and obtain possession thereof. And after such re-entry and resumption of possession, the authority shall be liable to refund to the lessee a sum equivalent to the premium paid in terms of this lease less 20% thereof to be deducted as service charge. So it is made clear that this stipulation of 24 months and 36 months for commencement and completion that can be extended on an application being made to the authority in that regard and on payment of such fees and penalty as may be imposed by the authority. And if there is any failure on the part of the lessee to comply with these terms, the lease will be terminated and the provision has been made for refund after resumption. Next, lordship will find the another clause that is 4.6 at seventy-seven. Yes. Lordship kindly note that 4.6. The terms and conditions of the lease shall be subject to changes of policy of the authority from time to time, and the lessee shall abide by the same. So this being the terms and conditions of the contract, the parties were agreed to these terms. Despite such stipulation, my lord, lordship will find certain dates. It is alleged in the allegedly stated in the writ petition that on 1st January 2013, they obtained mutation. That is at page 92. And they have also, my lord, relied on annex certain documents of 2013 and to the 2021 regarding complaint lost to the police station and so and so, but building permit was obtained by them admittedly at page 108 on 17 July 2015. The date is, lordship kindly take note of the date. 27 July 2012, the lease deed was executed. Under the, as per terms of the lease deed, plus 2.5, they were to commence construction within 24 months. But here, admittedly, on 17 July 2015, building permit was obtained. So thereafter, my lord, lordship will find at page 110. Oh.
Yes.
Just a minute. My lord, on 2nd June 2015, my lord, this letter of demand was issued by the authority to the LOT, being the petitioner. The undersigned is directed to request you to deposit a sum of rupees so and so as penal charges for the delay in construction and service tax thereon. So and so. Allotment shall be, and it has also been within 30 days from the date of issuance of this letter. Allotment shall deem to be cancelled if the payment is not made within the mentioned time. So this demand was made. This is the case made out in the writ petition. I am placing this. And then, my lord, the petitioner's reply to this at page 112. Reply to this demand. Lordship will find, may I read this? With due respect, this is to bring your kind notice that you have issued the aforesaid memo as penal charges for delay in construction for the land allotted by your good self. We have not started the construction due to our deep financial crunch. We have applied for bank loan for the said construction, which is in progress. It will be sanctioned shortly. But also, we have got the sanction plan in late. We plan to start the construction very soon without any fail. This shows, my lord, admittedly in November 2015 also, they admits that they have not started construction. And they could not start construction due to the reason is due to deep financial crunch, not any other reason. Here, pausing here for a moment, my lord, before this demand was made and the reply, in between, there was not a single correspondence or communication made by the LOT to the authority expressing any of their difficulties in complying with the terms of the contract. There was no correspondence and communication. Thereafter, Lordship will find at page 119, the cancellation order notice was issued by the authority. Here, Miller, may I read the terms? Whereas it has been verified from records that the plot number so-and-so at sector C under the East Calcutta Area Development Project allotted to Genesis Institute of Management and of Technology by letter number so-and-so. Whereas physical possession of the plot of land of plot number so-and-so at sector C under the East Calcutta Area Development was handed over to Genesis Institute of Management Technology on 4th May 2012. And whereas according to the condition at clause 2.5, which I read, my lord, 2.5 of the lease deed executed on 27 July 2012, the LOT were required to initiate the construction for setting up of an healthcare related institute within 2 years from the date of execution of the lease deed, that is within July 2014. And whereas it has been further verified that the LOT has not started construction within the stipulated period. And whereas the LOT has failed to take step for construction on the plot which was allotted in favor of him, which is clearly in violation of the said condition of the lease deed. And whereas the LOT was given demand notice to pay to payment of penalty amounting rupees 84 lakhs so and so for delay construction, but failed to submit the penal amount on being satisfied that the LOT could not produce any substantial evidence for non-construction, therefore, for violation of clause 2.5 of the lease agreement, and as per the approval of 179th authority meeting, the offer of allotment of plot number so and so is hereby cancelled. Possession delivered is withdrawn. Lease deed executed stand cancelled, and the land is resumed in favor of the KMD. Against this, my lord, in 2016, a representation was made by the petitioner, which is at page 20 and at page 120. After this representation was made in 16, this cancellation was made in 16, until 2022, when this writ petition was filed, there was no step was taken by the petitioner after making this representation in 2016. Till 2022, no step was taken by the petitioner. And in the writ petition also, there has been no explanation of such delay in approaching this honorable court. In the writ petition, it is categorically stated by the petitioner that before cancellation, no opportunity was given to them. But this fact is a suppression of material fact, because if your lordship kindly takes up my affidavit in opposition, a very material fact the petitioner has suppressed in his writ petition in order to obtain a favorable order by showing that no opportunity of hearing was afforded to them. Lordship will find from my reply,
Vote, yes.
my opposition, Lordship will kindly come to page 18 of my affidavit in opposition. Certain documents will itself show the conduct of the petition.
Page 18.
Page 18.
Yes.
One eight. Lordship will find this is a prayer. This is an application made by the petitioner to the authority. The above plot, subject, I'm skipping that. The above plot was given possession to us on 5th December 2012. We were to start construction on 5th May 2014 as per the terms of your above mentioned letter. We have taken all necessary action for the construction of the said building, including submission of the plan to the KMC. The file is now in Municipal Building Committee and the final sanction is expected shortly. Next, since the file is presently pending with the KMC, we would request you to grant an extension of 6 months, that is 5th November 2014, by which time we will commence construction work positive. This letter was not disclosed in the writ petition. So they have prayed for time. They admitted even on May 2014 that they could not start. Even the plan is before the KMC authority that was to be granted. That is why extension of 6 months was prayed for. Lordship, kindly turn to the next page. In response to such prayer, the authority wrote to the petitioner, issued a show cause notice. That Lordship will find the show cause notice for delayed construction in plot number so and so. And whereas it is verified from the records that a plot so and so was allotted to Genesis Institute of Management Technology by the office number so and whereas possession was handed over, lease deed was executed, and whereas according to the condition at 2.5 of the lease deed executed on 27 July 2012, the LOT was supposed to initiate the construction within 2 years, set up from the date of execution of this deed of lease, but it has been seen that the LOT has not started construction as per the lease deed. So he is asked to show cause as to why the allotment will not be cancelled as per the existing clause of the deed. This is, my lord, dated 11th November 2014.
This is also not disclosed.
This was not also. Now, Lordship, kindly turn to the next page. This is the reply to the show cause. Whereas it is the specific contention of the petitioner that they were not even given any opportunity. No show cause, nothing. He is replying to the show cause. My lord, I am not troubling your Lordship the earlier part. Lordship, kindly come to the penultimate paragraph at page 20. This refers to, my lord, why I shown to your Lordship the page 19, the date, 11th November 2014 at the bottom, under the signature. This refers, Lordship will find at page 20, the subject, reply of your letter number so and so dated 11th November 2014. So he is replying, the petition is replying to the show cause. Lordship, kindly come to the penultimate paragraph. Our earnest request is, please give us some time as mentioned above, and whereas according to condition at clause 2.5 of the lease deed, we are ready to pay such penalty within a reasonable rate as may be fixed by the KMDA, grant to extension of time to commence and complete and commission the project on the demised premises. Here they have undertaken to pay the penalty which would be imposed in order to commence, complete and commission the project. Then, Lordship, kindly turn to the next page. Page 21. After this letter was received, my lord, the authority agreed to extend but subject to conditions. This is my lord dated 24th March 2015. My lord got it?
Yes.
Page 21. May I read this? This is to inform you that the competent authority has agreed to consider your prayer for initiation of the construction of the house or plot of EKADP in principle on the following condition. You shall have to pay the penalty as per the existing rate of KMDA up to the date of initiation of the construction completion. So this was the first condition. The second condition, you will have to give an undertaking on non-judicial stamp paper within 10 days on receipt of this letter that you will initiate the construction within 6 months as per the lease deed from the date of permission. So these two conditions were imposed for granting extension of time as prayed for. These conditions, the petitioner then only, my lord, this was issued on 24th March 2015.
Yes.
These were not complied. Then, my lord, lordship will find that no such undertaking was given. This was issued in March, and then, my lord, the demand notice, which I have shown to your lordship from the writ petition, they have annexed the 2nd June 2015. They have annexed at page 110. I have shown to your lordship. This is the same demand notice. That this demanding penalty. This notice was issued. They have not paid, although the time was stipulated for payment. And then turn to the next page, page 23. Then final notice was, reminder was issued to them
Yes.
that you have failed to, last paragraph, but you have failed to submit the penal amount. You are hereby asked to submit the search within 1 month. Then another 1 month opportunity was given. They have not done so. On the contrary, my lord, lordship will find that many things has been said in reply and supplementary affidavit, but lordship immediate reaction of the petitioner, lordship will find the next page 24. This letter, of course, my lord, annexed to the writ petition also I have shown to your lordship. Here, no other ground, no ground other than the financial crunch was disclosed. This is the letter I have shown to your lordship from their writ petition also.
Yes.
So, my lord, since in spite of opportunity given to them for extension, as per our existing policy, my lord, we agreed to extend, provided the petitioner pays. He agreed to pay. And thereafter only this condition was imposed and the demand was raised. But seeing the demand, he has neither paid the demanded amount, nor submitted the undertaking. Then, my lord, the matter was placed before the authority meeting. That is, starts from page 25. I am showing your lordship the relevant portion at page 30. This is a committee, Land and Flat Allotment Committee, which is constituted under section 23 of the Town and Country Planning Act. Lordship, kindly come to clause 4.12. My lord, got it? This is regarding this petitioner's allotment. Genesis Institute of Management and Technology, failure to pay the penal charges. Because the entire matter was placed before the committee. The committee reviewed that. The committee opined that no waiver of penal charges for extension of time may be considered. After detailed discussion, it was decided that as Honorable Chairman KMDA has given extension of time on payment of penalty, the matter of cancellation of allotment of land of Genesis Institute of Management and Technology at EKADP due to failure to pay the penal charges within the scheduled time may be put up to the authority for decision. Here the authority means the board. So it was decided to place this before the board. Then your lordship will kindly turn to page 30, page 34. This is the resolution of the board. Lordship, kindly come to the relevant portion, that is at page 41.
42.
41. Regarding this 4 point, this is for 1, 2, third paragraph from top.
Yes.
4.1 Genesis Institute of Management and Technology failure to pay the penal charges. The authority decided to cancel the allotment of land of Genesis Institute and Institute of Management and Technology at EKDP project. So board has also decided to cancel the allotment. And then only, my lord, the letter of the cancellation was issued. Lordship will find at page 45, which is under challenge in the writ petition. And then, Lordship, as per terms of the contract, my lord, after cancellation, page 46, Lordship will find that we have issued the refund advice and send it to the petitioner's address. And for page 47, Lordship will find the Xerox copy of the check. It was not accepted. Then again, page 48, we have again send it to the petitioner's address along with the check. And then, my lord, page 50, we have resumed the land.
Page 50.
Page 50. This is with regard to the resumption of land. And page 51, Lordship will find some photographs that we have resumed that. Page 52 also with regard to that. Page 53, again we have issued another. We have attempted, my lord, even for the third time to refund the amount. We have sent the check, my lord, to the address of the petitioner. But from our record, we find, my lord, that the amount was not encased. So what we did, my lord, in terms of the contract, there it is specifically stipulated there for commencement and the completion. In case of necessity, he could have the allotee could have prayed for time, stating the reasonable grounds, and the authority could have granted extension at his discretion, but subject to, and there itself also subject to such charges or penalty.
That was prayed, but much later.
Much later. We have agreed to extend the time subject to the condition. He also, penalty was demanded. He agreed to pay the demand. But when we put the conditions, he did not respond to that. And after waiting from 16 to 22, after waiting for this 6 years, he approached this honorable court. And 6 years delay, why he has come after more than 5 years, there is no explanation in the writ petition. This issue, another, today we have already.
Will you continue some other?
Yes, some facts are more, my lord. I shall please.
Please request Mr. Siddiqui to be present on the next section. Yes.
To be supplementary, some facts are very material, my lord. Then only the judgments will take time, no problem.
Or learned counsel on
Would
behalf of the
it be
KMK?
possible on
Yes.
next it be possible?
My next Friday.
Next
Next Friday.
At the same time,
Or will you come back on 20th?
20th Monday.
Wednesday. Wednesday.
Wednesday. Very well.
Yes.
Goodbye.
20th. Let the matter appear under the same heading for further consideration on 20th.
At 12:30, my lord.
12:30 is being difficult because mentioned matters.
Mention matters are there.
Let it appear and take up.
As you wish.
We are now Janmashtami mood.
271.
Well, 271 I have for the petitioner. Well, this is the case where the vehicle was blacklisted. Now, your lordship desired that respondent number 4 and 5 be served.
Yes.
We tried, the petitioner don't have the present address, sent personally. Well, kindly keep it after 4 weeks. I will take out an application for substituted service.
You are 4 and 5.
4 and 5, the private respondents.
Oh.
It is a fraudulently, they obtained no objection.
9th October.
I mean, notice service টা হয়নি আমি কি জোসেফকে বললাম যে হচ্ছে না
Since service upon the
For
private
substitute
respondents is
services.
not complete, comma, let the matter stand over till 9th October.
my lord আপনার কিছু নয় সাবস্টিটিউট সার্ভিস
না আমার কিছু নেই, আমার আসতে
So I am for the writ petitioner, my lord. These are 5 bunch of writ petitions, my lord. On previous occasion, I have filed 2 supplementary affidavits pursuant to lordship's leave, where I have annexed all the receipts of the payment of license fee for 3 years, my lord, because the allegation was made that
5 different stalls.
for 5 different stalls, my lord, as per the letter of allotment, my lord, the commencement date started from 22nd of August 2021. So I have paid in the last supplementary affidavit, I have paid, my lord, for
He doesn't look very confident. Yes.
Yes, ma'am.
Let us hear it.
Yes, ma'am.
Where is it?
Actually, what happened, Malad, that exception is ready, Malad, but not affirm, Malad. You should kindly give Malad 10 days time, Malad. I can.
I was reading this from his face. That's why.
because, my lord, what I have enclosed are all the documents of the railways. Now they cannot deny. I am enjoying it because I am still under the operation.
Yes.
No problem is there.
If my learned friend says no problem, then
I wish I could record his submission.
Yes,
I'll kindly record this.
Malad model station, Malad.
Monday. Oh.
Coming just.
And whatever is the stipulations, my lord, as per
After
the
vacation?
after vacation, my lord, kindly make it.
Vacation, Malad, is too late, Malad.
But I am paying.
Change
Lordship,
all.
then lordship kindly,
You has been changed, Malad. Your lordship, no.
then lordship kindly come to my supplementary
Before
affidavits.
vacation, Malad, any time, Malad.
No, before vacation, my lord, lordship has heard it on several occasions, my lord. I have a very good
That is why,
case
Malad.
Come back after vacation.
after vacation, my lord.
Let it be,
Extended for
Malad, let
some
me
time.
part hard, Malad. That would be better, Malad.
No, let it be after
I
vacation.
cannot.
Part hard
clarify
চাইছিস না
that.
তুই?
No, part my lord, this is one prayer.
No.
Part hard, Malad. That is better, Malad. Again,
Rejected. Prayer refused. On prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 22nd November.
Hey, advance copy.
Paragraph, please serve advance copy.
Advance copy.
Paragraph, the interim order granted earlier is extended till 30th November or until further orders, comma, whichever is earlier.
And the next 5 matters are same, my lord. Till 276.
72, 76.
76 of the same order.
Grateful, my lord. My lord, kindly direct them
Want to
to.
file exceptions in all these matters?
Yes, yes.
But probably they don't have any ground to file any exceptions, my lord. I have paid everything, everything.
Stop them.
Let them file advance copy, my lord. So that I can prepare also.
Diploma. Great.
Seventy-seven.
My lord, I am for the petitioner in this matter.
Have you received a copy of the report?
No, ma'am.
So Devroy, not served.
I'm sorry. I've ended this one.
I have received now, ma'am.
Yes. So you want to come back?
Yes, my lord. If
I shall know that.
But I need time to go through this.
Let him come back. Report in the form of affidavit submitted on behalf of the respondents is taken on record. State respondents. Paragraph, copy of the report is made over to learned counsel for the petitioner in court this day. Paragraph, on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 4th October.
Well, deeply alleged.
78. The petitioner.
My lord, today is fixed for filing of report by the state. I am filing one supplementary affidavit, my lord, incorporating Justice Somin Sen order and recent order passed by learned Alipur Court. Page number 7, para 2.
For the state, my lord, I am appearing on behalf of the state. I am led by Mr. Supratim Dhar. My lord, unfortunately, report has no, my lord, I have not yet received the report. Kindly grant 2 weeks times, my lord.
How many weeks?
2 weeks.
My lord, my humble submission, my lord, may kindly seize the para 2, page 7 of my supplementary affidavit.
The order.
My lord.
My lord, just yet I am receiving.
ঠিক আছে my lord ki khali perusal kori.
Next occasion, because
My lord, because my lord, at page number 9 also, my lord, may kindly seize, my lord. Page number 9, Lanet Alipur Court has clarified one order, my lord, which is the subject matter before this court also. My lord, I am reading the page number 9.
So page 9 in your, oh, this is, before 8, 9 has come.
Oh, my lord, my lord.
You've not stitched it properly.
I'm sorry, my lord. I will stitch it properly. My lord, today the petitioner files photocopy of order of Honorable High Court, dated 21/4 passed in WP 11061 of Satro, wherein in page 2, para 2 of the said order, there is a prima facie finding of Honorable Court that petitioners are the holder of patent in respect of technology applied for battery operated rickshaws. My lord, this is the very important thing and subject matter of the 67 writ petitions also, my lord.
Not denied by any of the parties.
My lord, they have
all
obtained,
say that their batteries are different from yours.
but I am not having patent over the battery. I am having the patent over the technology.
Yes.
Applied for the technology.
Next matter, I appear for the state.
My lord, let the next matter be called. Let the
position.
my lord,
Sometimes say
in this matter, whether my learned friend
in
is
the next
appearing. my
matter,
lord.
if any order is passed in this matter, that will bind the next matter also.
Whatever is the fact on record, whatever is the fact on record.
Stage এখনো তোমার আসেনি।
This matter is being adjourned.
My-
Supplementary affidavit submitted on behalf of.
Madam,
the
may I
petitioner.
tell only one request, Lord?
Let me adjourn the matter. I'll call your matter.
No,
Supplementary
in this
affidavit
matter also.
Submitted by the petitioner in person. By the petitioner is taken on record. A paragraph, learned counsel for the state respondent seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on
না, আমি কিছু তোমাকে
3rd October.
হ্যাঁ কি হলো আবার এদিকে সরে এলে?
আমরা রেসপন্ডেন্ট হয়ে গেলাম এবার।
কি জানি শুনতে পেলাম কতদিনে একজন এটাতে আমি আছি হ্যাঁ
But in this matter, I'm appearing on behalf of the prisoner. But in the last occasion, matter was called, and all those two matters was one matter was disposed of. This matter was not raised. So I mentioned the matter. Then one is objection matter were adjourned. Or a similar order was passed on the same day, or just a few days back, on 2 or 3 days back.
Mr. Sen is appearing in this
Well,
matter.
I appeal.
What is your prayer?
My lord, writ petitioner is the defendant in the suit, my lord. And they have filed a written statement also. Here is the written statement filed by the writ petitioner. My lord, it was suppressed. Yeah, and my lord, Justice Sen lordship has been categorically directed that whoever are the parties in the suit, their registration will be declared as ab initio void in presence of the learned counsel for the state.
Yes,
My lord, that
That's
order.
wrong judgment, one wrong decision.
My lord,
What is the decision?
you have to challenge.
One suit was filed long back. but that was withdrawn
Please, have you received a
on
copy?
withdrawn on
please?
16 December 2022.
Mr. Khan, have you received a copy?
I have not got.
It's a voluminous document.
My lord,
No,
And you are
that
not
document I have not received.
My lord,
I have not received. I have not
my
received.
lord, so directs, I will,
You have to, because the other party should be aware of this.
my lord,
Well, may I tell
being
one
a
thing?
responsible,
This
my moral
was
responsibility to
was
advise the-
withdrawn with 6 December 2022.
That is a different suit, my lord.
just now, just I want to tell this.
Just the order in regard
That
to
is why, my lord, I
CS
want to-
in which he is a party.
Yes, Mr. Singh.
I want to tell one thing for lordship. Whenever, my lord, you want to place any order in respect of either in High Court suit or in any, my lord, the court below the lower court suit, my lord, kindly ask him to place all the orders which have been passed in those matters or related matters, either by way of any GA or other, my lord, the matters, but my lord, in the main matter, the main suit, whatever the orders till date pass, whenever you want to rely upon any order, my lord, lordship kindly ask him to place all the orders, because there are many orders, I know, my lord, that though I am not a party therein, but the order subsequently varied or modified at the instance of other dependents. So lordship kindly ask him, there are instances that he placed one order, whereas subsequently that order has been modified. So lordship kindly ask him, whenever you want to place any order passed in that suit or other matter, let him place all the matters till date, so that my lord can come to a conclusion. Yes, this is the stand of the court.
I think.
My lord, I concede with my learned friend's submission.
Mr. 1 minute, Mr.
My
Singh.
lord,
I think
December
the
2000.
petitioner, I think, Mr.
হ্যাঁ,
Khan,
এটাই ভালো।
you can come back with all the orders of the court.
Yes.
Well, I have not have like only one
No, no,
suit
no.
was meant that was withdrawn. I don't know what
No,
the
no,
what's the order.
let him come.
And that suit is different.
He says the number is.
There is no suit pending in my case also.
My lord, let me
Only
read the
one
order.
suit
It
was
will,
filed
it
that
will free.
withdrawn.
আরে সেই জন্য তো বললাম,
Confusion, my lord.
সেই জন্য তো বললাম একটা অর্ডার হোক যে ও সব অর্ডার
Come
গুলো
to
নিয়ে
the
আসে।
prima facie
Mr.
finding.
Sinha will place.
Sir, kindly let me allow me to
That
read
was
the
in
order.
the past was in the year
Sir,
2017.
kindly allow me to read the order. The
There
court
were so many orders
The
was
court
passed.
has come to the prima facie finding that on 17 June 2015, that the plaintiffs who are the writ petitioner in the proceeding are holders of patent in respect of technology applied for battery operated rickshaws, and parties to the suit were restrained from infringing the plaintiff's patent in relation to eco-friendly vehicles. The state is aware of the said order. In the event the state has granted any of such license to the defendants in CS 388 of 2014, my lord, that number is different, this is different. CS 388 of 2014, those registrations shall be immediately cancelled as the state has acted in violation of the order of injunction, and any such grant of license is void ab initio.
This is not a blanket order, sir.
2017 order.
My lord,
Now the
this
order-
absolutely, I concede with your lordship. The order is only restricted to the parties to the suit.
No, not
Lord,
only that.
it was reflected
It
in
is
the,
restricted to your patent in relation to eco-friendly vehicles.
my lord.
So now we have to
My lord,
decide
in-
first whether the registration is in respect of your eco-friendly vehicle.
My lord, now, my lord, in this regard, my lord, my humble submission is that, my lord, the Plaudit Techno, who is the writ petitioner here in this writ petition, is the defendant in CS 388 of 2014.
Maybe there is no
My lord, they have
restrictions.
filed a written statement.
Yes.
As per the Justice Sain or Lordship's order of declaration that who are the parties in that suit, those registration will be declared as
No,
ab
not
initio
at
void.
all. You have not understood the order, sir. I'm sorry.
My lord, kindly, my lord, if they will come in the writ court and they will say that I have the different battery, how can it be proved? My lord, how can it be proved when the matter is sub judice before the
When you
suit
are
court?
alleging something, it is for
All
you
the
to
orders
prove.
passed
My lord, it
subsequently
will-
by
it
your
will-
lordship
it
and other coordinate.
My lord, it
Then
will
what will
create,
happen in
it
those
will
orders?
create,
When
it
he
will
said
create, my
he
lord,
agreed to that order. Okay?
My lord,
Key matters.
my lord, this order, my lord, this order is restricted to the parties who are.
Is it your case that the petitioner is registering vehicles which are covered by your patent?
My lord,
That is your case?
my lord.
So let it be decided on evidence.
No, my lord, no, this is not because it's a leadership battery. I have annexed already. It is not because he's the pattern is a fuel cell. My battery leadership battery. So on this side is not so many matter what was passed. I have annexed the, my lord, the battery. I have annexed page number 153.
Fuel cell is one technology.
Fuel
Lead
cell battery,
batteries
fuel
is
cell
another
battery.
technology.
Well,
When you
it's a
talk about
different technology. I have not
technologies,
46
battery
matter
doesn't
was
mean
different
that box.
mistakes.
You say you do not have, you have patent over the technology and not on the battery. It is a fact because battery means technology of the battery.
Already decided by
Battery
Lord.
doesn't mean the box.
Several order by you,
Isn't
your
it?
lordship.
My lord, I
You
concede
cannot
with your
have-
lordship, my lord.
You
My lord, I
cannot
concede
have-
with your lordships, my lord. My lord, my humble submission is restricted to holders of patent in respect of technology applied for battery operated rickshaws. Battery operated rickshaws, it was reflected in the order.
Holders of
I am
your
on that only.
Holders
I
of
am not
your
on his
technology.
submission.
Not all technology.
My lord,
Holders
let
of
me
your
file the
technology.
affidavit.
No, after the
My
order,
lord,
after 370
my
years.
lord, one more order, my lord, I am citing. My lord,
Decided
one
by
more
Lord, by
order.
your lordship.
I am afraid the orders are not helping.
Already
you.
My lord,
decided after
kindly,
this.
kindly to hand over. My
These order also placed in a long back.
Mr.
My
Khan,
lord,
let me
decided your
deal with the
lordship.
matter. Please take your seat. Let me deal with it.
My lord, one more writ petition has been filed by Plotted Techno writ petitioner before the Justice Orindam Sinha Lordship's Court. My lord, on 5/10/2018.
By the same writ petitioner?
My lord,
No, this is by Twinkle Tradecom.
my lord, the Plotted Techno is at page number 2. Techno India Private Limited. My lord, in this writ petition
Plotted
also,
Techno India, where is Plotted Techno India?
my lord, in page number 2, my lord. My lord, Plotted Techno, herein, my lord. Herein.
Plotted Techno India,
My-
yes.
My lord, thereafter, my lord, may I take your lordship to page number 4?
But at that
Yes.
time, this distinction was not done. This
My lord, page number
distinction
4.
was not
My
done.
lord,
After
my
that,
lord, I am
distinction
not
was done.
allowed to make submissions.
তো আর কত বলবে?
না আপনি যদি বলেন আমি বসে যাচ্ছি স্যার আপনারা সিনিয়র
আর তোমার ব্যাটারি এনার্জি
Yes,
my
yes. tell me.
my lord, may kindly seize the page number 4, my lord.
Yes, page
In
number
all
4.
this writ petition, applicant appearing in person filed for intervention. My lord, I have filed intervention. As usual, they have not made me party. Applications appearing in person relies on order dated 21st April 27, passed by.
The same order has been reflected here.
My lord, now
This
the
is nothing new.
my lord,
Yes.
now the findings part.
Yes.
My lord, they have made submission that the similar submission which they have been making here, they in union submit that intervener is neither necessary party nor a proper party. Direction in the order, my lord, it is their submission. Dated 21st April 2017 are confined to the defendants in the suit being CS 388 of 14. My lord,
Where are you
Yeah.
reading?
my lord, page number 4. My lord, their counsel made submission before the court and now they are saying it is not binding. Directions in the order dated 21st April 27 are confined to the defendants in the suit being 388 of 2014 and now in 2023 their battery changed. ভালো করে নিন এবার কালকে পেন্সিল ব্যাটারি নিয়ে করবেন and do not affect the others who are not parties thereto. My lord, it is their submission, their counsel, my lord.
Maybe.
My lord, thereafter, Mr. Sain, learned advocate, additional government pleader appears on behalf of the state and submit in compliance of the directions made by the division bench of this court. There is a necessity of compliance. My lord, these
Issue
are the
was
motor-
different,
motor
totally
vehicle rules.
different.
It would appear from the extract of the
Total
order.
different issue.
126 compliance.
My lord,
Yes,
that
totally
is
different.
a 126 compliance.
Yes.
It would appear from the extract of the order. Now I am reading page number 5, para 3, my lord.
Yes.
It would appear from the extract of the order dated 21st April 2017. State was told to cancel registration or license if granted as void ab initio. It cannot be determined, my lord, this is the important thing. It cannot be determined at this stage whether registration granted or to be granted is confined to or includes person who are not parties to the suit. My lord, the other thing was also clarified by his lordship that who are not parties, whether it is applicable on them, it was also raised, question was also raised.
This
What is
order
important?
is with regard to your impleading yourself as a party to the
My lord,
petition.
thereafter, my
Nothing
lord,
more at all, not
my
on the
lord,
merits
the
of the
honorable
petition.
court has recorded one more submission, my lord. That is important.
These are submissions,
My lord,
not observations.
My lord, the honorable court has recorded after order on intervention application has been passed, petitioner in unison submit by reason of transport department having modified impugned order, they no longer want to place this petition.
How does that
This is
help
the
you?
stand.
How does that help you in this writ petition?
My lord, in this writ petition, my lord, 2 points were clear. They have filed a earlier writ petition, my lord, Plotted Techno, in which they have made submission. Their counsel have made submission before the honorable court that order dated 21st April 2017 is binding on the parties who are the parties in the CS 388 of 2014. My lord, in the CS 388 2014, The present writ petitioner is defendant number 134. They have filed a written statement. Suit is pending before the court. Grant me an opportunity to file the affidavit. I will bring all the
Not necessary,
orders, my
not
lord.
necessary.
My
Only
lord,
one thing, Mr. Khan, you have to show that you were granted liberty to file a fresh writ petition. You withdrew your writ petition on the earlier occasion. Unless the court granted you liberty to file a fresh writ petition on the same cause of action, this writ petition will not be maintainable at all. Where is the liberty? Because yes.
5th October 2018.
Yes.
So many writ petition was analogously hearing. Analogously hearing. One of the writ petitions.
The writ petitions were withdrawn. Writ petitions were withdrawn, not pressed. So there should have been liberty to file a fresh writ petition. Where is the liberty?
On this is another cause of
So
action.
please show me the
Cause of action because
please
that
show me the cause of action of the earlier writ petition.
no, earlier writ petition because I am not a counsel on the earlier writ
Please,
petition.
I need to see the if it's the same cause of action,
Yes.
then this writ petition will not lie because no liberty was granted. I need to see the earlier writ petition.
Earlier writ I should check up.
WP 17397.
The earlier writ petition, to some extent, facts are, my lord, narrated in the order itself at the first paragraph. Here now I recollect, my lord, that an order was passed by the transport department, my lord, to stop, my lord, manufacturing of assembling or selling of Toto at that point of time. That, my lord, that because there is an order of the Honorable High Court, Calcutta, and contempt petition was also pending with regard to unauthorized, unregistered, my lord, the e-rickshaw. And that order was challenged, entire different thing. That order was
I would like
challenged.
to
It
see
had-
the petition,
Yes,
the writ petition.
Only
Mrs.
check up.
Mrs. Sinha, do you have a copy of? the
yes,
petition?
yes.
my lord, I will,
They-
I will file by way of a supplementary affidavit if your lordship so directs.
Just provide me with a copy of the earlier.
Fine.
writ. I would just like to see what. the cause of
Yes,
action
now
is.
I recollect, lordship, because I myself
Sinha is
appeared.
appearing in the writ petition.
The problem is that in each and every day, when the point is already settled long back, on the sales of the action, so many replaces was moved and every day, he is coming to.
Every fact must be brought on record before the honorable judge.
In any event,
Because
supplementary is
Now
already
it is a
so now.
different issue altogether.
Now the writ petition, only for issue writ petition, nothing else, no other issue.
The writ petition, Mother, kindly direct them, either of them kindly, mother, place the same by way of a
I
supplementary
think it would be
affidavit.
better if petitioner places because it was his writ petition.
Yes,
Okay, I short date, my lord, because the marriage.
by way of supplementary affidavit, let
Within a
them.
week, I said, fine.
My lord, if
can
your
take this
lordship so
back.
directs, my lord, I will serve this copy also to my learned friend.
If it helps, I do not.
My lord, if it helps my learned friend, I have
Because
no
the
objection.
portion of the order that you have shown really doesn't help you. I must share with you.
My lord, my sole motto is to bring all the facts
Because
before
it
you.
is not that all the defendants are restrained. The defendants are restrained if the technology is your patentee technology. Only in that case, they are restrained, not
Because
otherwise.
that is
My
the
lord, I
case of the
accept, I
Patent
accept.
Act
If the
and the
technology is
suit also.
different,
Not
there
only
is
this,
no
my lord, in
part.
one matter,
My lord, I
consent
accept.
of
I
the
consent
both
to that
parties. order was-
proposition.
Between patent on battery and patent on technology.
Yes.
There is nothing as.
My lord,
patent on
I
battery,
concede,
sir.
my lord, I concede to this proposition very long back ago before her ladyship.
Technology.
Lakshmi Bhattacharya lordship, ladyships, my lord.
Already
My lord, my humble
Already order has
submission is that this
Already
order
order
will
has
not
order.
applicable on me. Because I have the patent over the technology
No, no, no.
by which it is
That is
applied.
not
It is
correct.
recorded in the order. Court will
No,
go with the orders only. Court will-
এটা কোনো order নেই।
Come back with the copy.
Yes,
of
sir,
the
with the
earlier
copy.
writ.
Have it set aside.
সুট কোর্টের
Affidavit
মেন
of
অর্ডারটা
service.
কোথায় তোমার?
আপনি করুন না।
Learned
আমি কিছু
counsel for the
আমার কি দোষ?
paragraph two,
আমায়
is
বৃত্তি
submitted
দিয়েছে
on
আমি
behalf
দাঁড়াবো।
of the private respondent that an earlier repetition being WP
যদি করতে আমি তাহলে
17397
আলিপুর কোর্টে তোমার
within
তুমি
bracket
কিচ্ছু
W
অর্ডার পেতে না।
2018
সেখানে
was
কি হয়েছে না
filed
হয়েছে আমি
by
সব
the
জানি।
কি জানেন?
present
সব জানি আলিপুর কোর্টে কি হয়েছে না হয়েছে কিভাবে কি
and
হয়েছে সবই জানি।
withdrawn
করুন না।
subsequently.
আমার কি দরকার আমি কি ট্রান্সফার
Paragraph learned counsel for the
আচ্ছা,
petitioner
আমি কি ট্রান্সফার
seeks
যদি কেউ
to
আপনার যদি কোনো
use a supplementary
না
affidavit
না আমি কেন
annexing relevant documents
সরকার বুঝবে শুটে শুটে অর্ডার
annexing copy of the earlier repetition. Relevant documents না করে
আমি
annexing copy of the earlier repetition. Paragraph let the matter appear under the same heading on
আমি কোনো
29 September.
করনি
এইটার জন্য
কি অর্ডার দিল
19 September.
29 September, I said.
29.
আর ইন দ্য মিন টাইম
In the binding supplementary.
Yes,
The only copy you will
the
place.
writ petition,
No, no,
copy of the earlier writ petition.
My lord,
By
I have produced copy or my learned friend will
Always
provide.
closing by way supplementary or place the writ petition. to your
Come back with a supplementary.
Supplementary affidavit.
280.
29.
Yes.
This matter, petitioner of the permanent contractor permit holder in respect of the
Take the microphone, please, madam.
Microphone touch.
Lordship, in this matter, petitioners are the contract carriage permit, auto permit holder in respect of the route Baguihati to Ultoranga and Ultoranga to Baguihati. The permit was issued by the Regional Transport Authority, Kolkata. Lordship, I annex the permit, and regarding the issuance of auto permit, there are so many notification was issued by the State Transport Authority. My lord, kindly directly come to page 50. On 4th May 2023, this notice was issued by where it was indicated, consequent upon the publication of auto rickshaw policy of West Bengal 2028 by notification such and subsequent order of the Directorate Transport Transport Directorate by the number such and such dated as per the resolution of RTA North 24 Parganas Board meeting dated 4th May 2023, notice is hereby given invited application through online website portal for the below noted routes from the unauthorized auto rickshaw owners. The route was given in the said notification, notice, lordship. Thereafter, after issuing this notice, so many application was filed before the authority, and the authority issued offer letter, so many auto. But after expiry of the offer letter, the authority never granted permit in favor of the petitioner. But the auto rickshaw is plying in the route without any permit. I mentioned the number of the auto, but it is not possible for
And
me.
the auto rickshaw ply without any permit? You are admitting the mistake done by you.
Yes, lordship, mistake done by the authority. They issued offer letter, but after expiry of the offer letter, there are 3 months. Initially 30 days. Thereafter, it is extended another 60 days. But thereafter, in the meantime, the authority should issue permit. But after issuing offer letter, the authority never issued any permit, and the auto is plying in the route without any permit till date. But the notification is
You're admitting the offense, isn't it?
yes, lordship. I am the permanent permit holder. I am the permanent permit holder. I have permit in my favor.
So why
But
are you saying that the petitioners are not being issued permits?
no, lordship. I am saying that after issuing of this notice, so many respondent, I do not, so many person apply for permanent permit for contract carriage permit. After issuing application, the authority issued offer letter. But
Yes.
after expiry of the offer letter, the authority did not never till date.
Yes, Mr. Devra.
His grievance is mainly public interest litigation. Why they have not granted permit in spite of they have issued offer letter, daily public interest, and there is no
This is,
representation to that effect before the authority.
Not necessary.
Lordship.
Why will a representation be necessary? You have issued offer letter.
Offer letter.
Even after expiry of the valid period of the offer letter, you have not
Then
issued
my lord,
permits.
authority automatically cancel the offer letter.
Where is that document?
That I don't know. Whether
Lordship, kindly direct them to file a report. I indicated the vehicle number.
I take instruction to that vehicle.
Because all the vehicle numbers are indicated here.
Yes.
So please take instructions and come back, Mr. Devra. Because they are applying unauthorizedly.
Yes, Lord.
So many vehicles.
No, that cannot be.
Affidavit of service. Paragraph, the petitioners are contract carriage permit holders of auto rickshaws and complain that the Secretary, Regional Transport Authority, North 24 Parganas, Barashat, by a notice dated 4th May 2023, invited applications from auto rickshaw owners
At 180 days.
plying their auto rickshaws in the routes mentioned in the notice without any permit and permit, pursuant to which several applications were filed before the authority and offer letters were issued. Stop.
The offer letter, validity of the offer letter initially 30 days, thereafter total 180 days.
Yes.
So the date of May, 4th May, they have granted. So there are another 6 months is required.
There is still time.
Yes. They have time, till there is the time.
90 days, I think it's 90 days.
180 days for 141 of the rule, Bengal rule.
Of the state rules. West Bengal rules. One
141.
141.
To 6 months provided.
60 days.
দেখো 140 provided এ যাও।
Up to 6 months from the date of issue. In exceptional cases.
They have to apply. After
Provided transport granting permit
In
may,
exceptional
for
cases.
reason to be recorded in writing extended. That I don't know, my lord, whether they have extended or not. 6 months they are.
after 1 month, they have to
That is
apply.
up to November, the validity of the offer letter is still.
Roots, অনেকগুলো roots. So, but subsequently, no permit was issued by the authority for which the auto rickshaws are continuing to ply in the said routes without permits. Paragraph, learned counsel for the respondents submits that the period for issuance of permit in terms of Rule 141 of the West Bengal Motor Vehicles Rules 1989 has not expired as yet. Stop. Learned counsel seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 13th October.
You should file
A report, yes.
Two 81.
Well,
No, I am appearing on behalf of the South Bengal State Transport Corporation. Yes, sir. Mr.
For the
AK Mr.
petitioner,
Maharaj.
this is an application concerning the allotment of a tender, my lord. First tender was announced, my lord. It was cancelled due to certain reason that,
Relating to what?
my lord,
Tender of what?
the tender for my lord, repairing of vehicles, my lord. My lord, kindly come at page 15, my lord. The first tender was for my lord, daily maintenance of buses, my lords, of South Bengal State Transport Corporation, my lord. My lord, first tender was cancelled because, my lord, there were no technically qualified bidders were available, my lord. Thereafter, my lord, second tenders was announced, my lord. On the self-same terms and conditions, there is no difference in between the first tender and second tender. Only one point was differ from first tender to second tender, my lord. Kindly come at page 15, my lord.
15 is the affidavit, the last. page.
No, my lord.
No, the
My lord,
is the first page of the tender, my lord.
my lord, first page of the tender, my lord, my lord.
In my brief,
15A,
My lord,
B1.
my lord, sorry, my lord, it is wrongly.
the
Just
250,
after,
there
just
is a-
after the affidavit portion, my lord, just after the affidavit portion, my lord.
Yes,
Page 15, my lord,
yes.
and my lord, kindly compare page 38, my lord, side by side, my lord, if I compare, my lord, both the terms and conditions, 38, but that is my P4, my lord, kindly,
Yes.
my lord. Page 15, my lord, right hand side, first point, my lord, bidders should have experience of at least 7 years of fleet maintenance, my lord, 7 years, my lord. Thereafter, my lord, page 38, my lord, if I
5 years.
5 years, my lord. Thereafter, my lord, page 38, last point, my lord, intending tenders to produce credentials as per technical details of fleet maintenance of buses or ACB of 30%, my lord. First,
40%.
my lord, page 15 was 40%, my lord.
Yes, and yes.
Second one is 30%, my lord. What has happened, my lord? In this process of tender, my lord, certain bidders, my lord, participated in the process, my lord. They have disclosed their credentials, my lord. Knowing the details of credentials, my lord, the authority, without any reason, without any, according to me, my lord, without any approval from the government, my lord, they have announced the second tender, my lord. And second tender, my lord, we have raised objection because, my lord, on a particular organization has been allocated the tender, my lord, without considering the price bid, my lord. Because, my lord, the particular successful bidder who is now already been allocated the work, my lord, his price is per kilometer, my lord, 12 paise per kilometer. But my offer is, my lord, 10 paise per kilometer, my lord. So, my lord, my grievance is that, my lord, before your lordship, my lord, how the second tender has been announced, my lord, let them ask to, my lord, to file an affidavit in support of their contention, my lord.
the first tender, my lord, there is no qualified, the number of qualified bidder is not there. For such reason, we have cancelled that, and the second call has been announced, my lord. And in the second call, they have taken the plea that the is changed, the condition is changed, my lord, as per the government rules, my lord. If we are not receive the sufficient person to participate the tender, we can change
Cancel
the
it,
yes, my lord. For such reason, we have changed the two condition has been relaxed, my lord, and subsequently it has been made and in April 2023. And the page 39, my lord, kindly see the page
When,
39.
my lord, we have disclosed all credentials, my lord.
Page 39, my lord, all the event has been completed in May 2023, my lord, and presently they have challenged it, and as per my instruction, my lord, over telephone, that in the second call, one has been qualified, and since only one has been qualified. Only one has been qualified. We have sent the total file to the transport department for their reference and their consideration, my lord. That is my instruction, my lord.
Will you come back with a report?
Yes, my lord.
Yes, my lord. My lord, on affidavit, my lord, kindly ask them to file an affidavit.
Not
My lord, my
affidavits are
lord.
not required.
Yes,
Well,
yes.
my grievance is that, my lord, 12 paise and 10 paise, my lord.
You have stated this. Please come back with a report in the form of an affidavit.
Yes, ma'am. In the technical bit, there is no qualified person in the first call. For such reason, we have taken the second call, my lord. There is no question of any.
The notices inviting tender issued by the second respondent on 28th February 2023 and 27th April 2023 respectively, are assailed in the writ petition. Paragraph, learned counsel for the second respondent seeks to submit a report. Second respondent submits. Learned counsel for the second respondent submits paragraph that since there was no bidder for the first tender, comma,
Technically qualified bidder.
yes,
Technically
there
qualified
was-
bidder.
Since there was no technically
Sufficient number of
submits
technical-
that since there was no technically qualified bidder for the first tender, comma, the said tender was cancelled and the second tender floated with certain relaxations. Stop. Learned counsel seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 4th October.
My lord, only one thing, my lord, kindly consider prayer D, my lord, once, my lord. Kindly prayer D, my lord. Till dispose of the writ petition, my lord.
My lord, the tender is already in May, it has already been completed, my lord. And they have choose not to challenge that from that time, my lord. It is an, we are in September. There is no, kindly not grant any interim order, my lord.
Only, my lord, prayer D, my lord. Till dispose of the writ petition, my lord. Otherwise, my lord,
No, my lord, kindly, it's my submission is.
because my lord, we came to learn from the website, my lord, that my offer was rupees 10 paise per kilometer, and
The tender process is already complete.
Yes,
How
my
can
lord.
it
No,
include
no,
the
there
review
is.
at this stage?
And,
will
you
not
know,
help
my lord,
Your lordship
at least,
kindly-
my lord, abide by the result of the writ petition, my lord.
there is no.
Abide by the result of-
My lord,
Already-
kindly, my lord.
If your lordship.
Have any step taken by the
Implied,
second
my lord.
respondent pursuant to the tender dated 27th April 2023 shall abide by the result of the writ petition.
And if your lordship kindly consider page 54, on May, they have filed their complaint before that, but subsequently they have not filed any writ petition or anything. And after that.
My lord, we have lodged complaint, that's enough, my lord. Because we have drawn the attention of the authority, my lord.
They have prayed for the.
My lord.
I'm appearing for this.
Petitioner? Yes, your petitioner?
This is UNESCO Sira.
It's appearing for the first time. Let there be a date. None appears for the petitioner. No accommodation is sought. Paragraph, let the matter appear in the monthly list of October 2023. Appear under the same heading. No? In the monthly list of October 23.
Or I appear for the petitioner in this matter.
Respondents?
Lord, page 14 is the application. The petitioner being the holder of the permanent residence permit during its validity submitted joint application. Page 14 seeking transfer of the permit under section 82 read with rule 159 of the rule making a joint application. The application was received on 4/4/2017. The permit remained valid till 22nd. The permit during its validity of the permit, it was submitted.
Yes.
But this application was received by the office along with the an affidavit. Page 17. After submitting the application and during pendency of taking a decision, another application was submitted seeking renewal of the permit. That is page 19.
Seeking renewal.
Renewal of the permit and supported by the fees and pursuant to the said application.
It belongs to the first petitioner. First petitioner wants to transfer to the second.
Yes, both joint application has been, rule requires so, 159. But pursuant to the said application, when a hearing was conducted by the office at paragraph 5, I have stated 29 May 2020, hearing was conducted. Nothing was committed to me. But I made the representation before the authorities at page 21. But even then, nothing was communicated, for which I sent a legal notice on page 22. But my humble submission, after submitting the application, I am entitled to know the fate of the application regarding transfer renewal of the permit. Nothing was communicated to me. My humble submission, yes, and if the decision is not taken, let them take the decision, also communicate the decision. Yes,
Affidavit of service. The
20 May. Hearing
First
হয়ে গেছে,
petitioner
কাগজগুলো দেখেছে সব।
is a holder of
কমিউনিকেট করে দিলে তার আসতো না আমার কাছে, কমিউনিকেট করেন বলেই তো এসছে, কমিউনিকেট করেনি বলেই তো
in
আমাদের।
respect of vehicle bearing number WB 4E/9133 in the route Borakar BORAKAR to Durgapur. Stop. The first petitioner intends to transfer the permit in favor of the second petitioner, for which both the petitioners submitted a joint application before the concerned authority on
4th of April 2017.
4th April 2017. The permit was valid up to 22nd April 2017,
Yes,
for which the first petitioner submitted a separate application before the authority for renewal of the permit. Stop. Paragraph learned counsel for the petitioners submits that though the petitioners were called for a hearing
paragraph 5,
with regard
29th
to both the
May.
applications on 29th May 2020, 29th May 2020, and attended the said hearing, comma, no further communication was made to them as to whether an order was passed in this connection. Stop. The petitioners seek a direction upon the authority to communicate the order, comma, if any, passed by the authority in connection with their applications. Paragraph learned counsel for the state, for the respondents submits that who should communicate?
Yes, my lord.
The secretary? The secretary?
But if decision is not taken, then
If the decision is not taken, then
RTA board will also kindly mention it.
So let it be the RTA, the second respondent.
Yes, my lord.
That the second respondent be directed to take necessary steps in accordance with law. Paragraph in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the applications submitted by the petitioners for transfer as well as renewal of the permit issued in favor of the first petitioner, comma, if not already disposed of, and communicate the decision taken by the authority to the petitioners within 1 month, within 2 weeks.
Within 1 month, because RTA board, my lord.
Within 1 month from the date of communication of this order.
পুজোর আগেই হয়ে যাবে।
Dispose of, if not, then dispose of and communicate.
If not, বলে দিয়ে দেবে সব।
Disposed of which article?
আছে আমার কাছে আছে তো কপি মানে আপনার যে ব্রিটিশ নাম্বার
Iris or Rule 83(1) of the West Bengal Motor Vehicle Rules is under challenge. I am to serve London Advocate General.
You are challenging the virus.
Iris, or Rule 83(1) of the West Bengal Motor Vehicle Rules 1989. And I am to serve London Advocate General.
Yes. Since since the virus of Rule 83 within bracket 1 of the West Bengal Motor Vehicles Rules, 1989 is assailed in the writ petition, is under challenge in the writ petition. The petitioner is directed to serve copy of the writ petition along with annexure thereto to learned Advocate General, Government of West Bengal, and file affidavit of service on the urgent date. Mr. Shamanta, after vacation?
It will kindly give some, before by this side, it will be
Let the matter
beneficial
appear.
for us.
Let the matter appear under the same heading on 9th October.
$285. $285.
Hello, Mr. Olsen is a yes or no?
Who is appearing for the petitioner? Anyone for the petitioner? None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading in the monthly list of October 2023.
$286.
Mr. Mukherjee for the petition. Mr. Mukherjee, you are appearing?
Kindly straightway come to, this is a rejection.
This is a
Rejection of my application for grant of stage carriage permit, which covers 2 regions and passes through another state. Your Lordship, straightway come to my order of rejection. The original copy is at page, the page ta koto eta? Page 28, I think so. And the type copy is at page 29.
yes.
Now, serial number, the type copy, Your Lordship has.
Typed copy I do not find.
Next page is type copy.
এটা কি পড়তে পারবে?
Type copy টা জজের ফাইলে দিছি বলতে।
কোনটা? এইটা কি টাইপ কপি?
Have you Lordship got?
এটা কি টাইপ কপি?
হ্যাঁ, এটা টাইপ।
মোবাইলের নাম কি? দেয়নি, মামলা আমাকে এখন দিচ্ছে হাতে, সুকুমার দে। এটাই কি? কোনটা? নাম কোথায়? নাম কোথায় রে? সুকুমার দে কোনটা? আমি কি করে বুঝবো?
Yes, 29 and 29A.
Serial number 123. This is Your Lordship, we find the serial number, column number 1, 2, 3, 4. 3 is the name of the applicant, Sukumar De.
Yes.
Now, the decision is at the last column. Application for permit is considered and rejected as the route originates and terminates in same region, district, and the number of region is 1. Applicant is.
What does this mean? Applicant?
It has to be. Yes. It has to be referred. They are saying that it is in one region. This is one region, and that's why he has to apply before the
regional transport authority or for that region. My lord, on that aspect, my lord, your lordship kindly come to my application. That is at page. Page 16. Page 16, my lord, of my writ petition.
Yes.
Your lordship will find that says
Page 16.
page 16.
Yes.
My lord, this is the applications. My lord, your lordship will find that Masaria to Jhalda via Chandoneshwar, Odisha and West Bengal. There are two states. Now, my lord, the Masaria and my lord Jhalda, it is one part is my lord in Purbo Midnapur and other part is Paschim Midnapur, which passes through my lord the Chandoneshwar and other part that is in the state of Odisha. Now, my lord, and your lordship will find that a 202, my lord, that is the next serial number of region, Purbo Midnapur, Paschim Midnapur and Odisha corridor.
Yes.
Now, my lord, your lordship is already, my lord, delivered a judgment on this, my lord, 69(2) of the Act.
Let the state explain why this has been recorded, why such a decision has been taken.
And my lord, another thing is that, my lord, it has already, your lordship kindly, my lord, your lordship kindly take one another aspect that this application has been made, my lord, on, my lord, kindly take the rejection, order of rejection. That is of, your lordship will find the order of rejection is at page
28th April.
yes, 28th March, 22nd March.
Application made on 22nd March.
Yes, and the order of rejection is, my lord, 28th of April. Now, your lordship, if your lordship kindly take up another matter, it is appearing in the list, item 88. But this is 86, the 88, same issue. There I have shown up, my lord, before rejection. Sorry, they have already granted on this particular route. The resolutions I have annexed. There they refuse to, my lord, that writ petition, in view of, my lord, the applications made for the same route, they refuse to accept the applications. And I send it through, my lord, the post. The next 88 application, writ petition 88.
Yes.
And there your lordship will find at page 30 of my second writ petition.
Yes.
There, my lordship will find that agenda number 33, well, page 30, page 30.
But these are not the part of the records. I cannot follow these, lordship.
No, only one thing.
Only or maximum. How can I follow?
Let them.
Let us deal with the first writ petition only.
Yes.
Yes. Now, my lord, there are two things. One is this, my lord, the decisions, my lord's decisions is there. The earlier decisions of justice, my lord, the coordinate bench of justice, Tandon's decision is there. And my lord, the notifications which refers to, my lord, I have referred this notification of 1995. There, my lord, I think photo লাগিয়েছিস না মনে হয় মানে মামলা করতে আসিস না বন্দে ভারত চালাচ্ছে না ওই জাজমেন্ট অর্ডারটা পুরো একটা কাজ করতে যাস মামলা করছে আর দিস নোটিফিকেশন হ্যাজ নট বিন অ্যানেক্সড কপি অফ দি নোটিফিকেশনটা দে
I think the state has to respond. Mr.
Well,
Singh,
this-
can
well,
you-
I do not understand
May I
what
please, Malad,
is
then
his
notification?
actual submission. First of all, Malad, one has to make submission that this is my prayer. And in support of that contention, then he can say that this is in support of my contention. But I could not follow, my lord. My lord, it appears that he has made an application for grant of stage carriage permit in respect what my lord, I have, my lord, after going through, he has made an application for stage carriage permit on inter-region route covering two states, two regions.
regions and 2 states also.
2 region, I'm coming, Lordship, 2 region within state of West Bengal and before the State Transport Authority. Now, first of all, let us, my lord, first let us concentrate on the point that whether if any application is made for, my lord, the stage carriage permit covering 2 region, then whether the STA has, my lord, can grant the permit or not. After, my lord, that 2013 or 2014 notification, where, my lord, STA said that if any application for permit is, my lord, made before the STA, then only that should be more than 3 regions. Irrespective of the fact that section 69 speaks about that the most of the, I think, the area that my lord falls in respect of the most of the area within 1 region, then that region only, but more than 3 regions, then before the STA. Now here, my lord, an application has been made for grant of permit covering 2 regions before the STA. Now the contention is that while covering the entire area or route where he sought for permit, then, my lord, he has to travel also, my lord, some portion of another state, which is, my lord, normally, my lord, says that the corridor restriction. Now, up to 16 kilometers, there is no question of any, my lord, permit from either side, so far the corridor restriction, because if it is more than 16, then, my lord, I think that the counter signature of the other state is required. Counter signature of other state is required if it is more than 16 kilometers.
Yes.
Otherwise, from, my lord, the starting point to end, in between this, if it is required for the purpose to cover the entire journey, then up to 16 kilometers of other state, I can cover as per the law. Now, the whole thing is this, whether the application made to the State Transport Authority, they have right to, my lord, consider this or not. Because application normally should be made before the authority or the region which has maximum portion in its control over the said area. Now here, my lord, Purbo Mednipur, kon region? Purbo Mednipur and Paschim Mednipur. He said that the starting point is Mosharia and the other terminal point is Jhalda, Paschim Mednipur. Now he has to, my lord, that he has to ascertain that in respect of this route covering Chandoneshwar, Odisha, that is within 16 kilometers, then in which authority he has to make his application, Purbo Mednipur or Paschim Mednipur, then there would be no problem, because his sole motto is to obtain a permit from a authority which has authority to issue the permit, not the fight with all the authorities or any particular authority. Here he made an application before the STA, and STA says, though the language is not, my lord, is not so clear, but it appears that sometimes, my lord, it happens, my lord, the language may not be so clear, but it appears that application for permit is considered and rejected as this route originate and terminate in same region, district, and the number of region is 1.
It's not at all the case. There are 2 different districts involved, another state involved. So when there is
No,
another
state has nothing to do, another state.
maybe counter signature is not required.
Counter signature is not required.
But the state is involved. Permit
Other-
is involved.
But other state is involved,
So
but
when another state is
but
involved,
the
does the
STA
RTA have authority?
yes, as per the law.
There is a judgment of a coordinate bench which is annexed to the writ petition.
My lord,
Page
তুই
22
আবার ছটপট করছিস।
I have annexed page 22.
Page 22 of the writ petition.
Yes. Yes. My lord, 88(1) proviso, if you will kindly have a look, my lord. I shall go through the judgment, but kindly, my lord, have a look, my lord. 88, section 88 within bracket 1, that stipulates the, my lord, that the, my lord, the mandatory provision of obtaining counter signature of the other state and or other region as the case may be. Then my lord, the second proviso provided further that where both the starting point and the terminal point of a route are situated within the same state. Have you also got it, my lord? The second proviso. But part of such route lies in any other state and the length of such part does not exceed 16 kilometers, the permit shall be valid in other state in respect of that part of the route which is in that other state, notwithstanding that such permit has not been countersigned by the state transport authority or the regional transport authority of that other state.
This is counter signature.
Yes, yes. Now, so now the only question is, so my lord, irrespective of that it traverse up to 16 kilometers of any other state or not. Now the thing is this, that whether the permit is, my lord, the inter-region route or not. If it is inter-region routes, and if the routes inter-region covering less than up to 3 regions, then my lord, he has to apply before the, my lord, that particular regional transport authority, which
law says so?
my lord,
Because
that is
88 second proviso is not applicable in this
my
case.
lord, the 69 sub, my lord, then I am coming the 69, section 69.
Yes, 69.
Because HTA is not the authority to grant permit all the time. এই ব্রিফগুলো আমাকে দেয়ই না, যখন মামলা হবে তার আগে আমার হাতে ব্রিফটা গুছিয়ে দেয়। General provision as to application for permit. Have you also got it, Madam 69? Every application for a permit shall be made to the regional transport authority of the region in which it is proposed to use the said vehicle or vehicles. Then again proviso, provided that if it is proposed to use the vehicle or vehicles in 2 or more regions lying within the same state, the application shall be made to the regional transport authority of the region in which the major portion of the proposed route or area lies. And in case the portion of the proposed route or area in each of the region is approximately equal to the regional transport authority of the region in which it is proposed to keep the vehicle or vehicles, then the choice of selection, otherwise where the major portion lies. Now, in 2013 or 2014, HTA. Now, in 2013 or in 2014, a notification has been issued by the State Transport Authority, my
In
lord.
terms of 2,
Yes.
69-2.
Yes. Notwithstanding anything contained in subsection of the state government may by notification in the official gazette direct. In the case of any vehicle or vehicles proposed to be used in 2 or more regions lying in different states, the application under that subsection shall be made to the State Transport Authority. Vehicle proposed to be used in 2 or more regions lying in different states. Application under that subsection shall be made to the State Transport Authority. Yes, and that should be, my lord, in terms of reciprocal transport agreement. Otherwise cannot be, because these should be read with along with section 88, my lord, subsection 4 and subsection 5. Because I cannot traverse beyond 16 kilometers to other state. I cannot direct any permit, issue any permit if I do not require any permit counter signature for separately, then that is not a region for the purpose of granting or issuing permit. Lordship, kindly consider, for the purpose of granting or issuing permit, the region means that the maximum portion. Lordship, kindly consider one thing. It is not a region for the purpose of that. It is that for the to facilitate, to cover these two regions, one has to, my lord, travel that region up to 16 kilometers.
That's why counter signature is not required.
Counter signature is not required.
Who will issue the permit? The Regional Transport Authority cannot issue permit for an area which is beyond the state.
There is
Observation in this judgment.
Then, my lord, Lordship, kindly give me some time, my lord. I have to consider it again.
Yes, if you can
I have to consider it again.
The judgment which has dealt with this issue, if you can come up with that judgment.
And my lord, here,
My lord, I have to consider again, Lordship.
my lord, 13th notification, that also dealt with.
Yes, that's why I'm saying.
That's what my learned friend is pointing out, that the 13th notification says you have to apply before the STA if the route covers more than 3 regions. That has also been dealt with in respect of those routes which not covered only 2 regions, but a covering is another state. That has to be dealt under section 69 subsection 2. And my lord, another part that has not been dealt with in this judgment, there is a notification of 1995. My lord, may I? That your lordships have held.
1995?
Yes, that notification says the State Transport Authority West Bengal only have the right to consider the applications which.
This still holds the field. This notification.
Yes, it has not yet been, my lord, superseded by any other.
Let him give a copy. I shall also consider that.
Please show me.
This.
না থাকলে সেটা কোর্টে দিবি না, সবসময় এক কপি করে আনিস কেন? মক্কেল কি জেরক্সে পয়সা দেয় না?
দেখা যাচ্ছে না।
ওকে বলো।
এই তাহলে অ্যাপিয়ারই করবি না, সবসময় তো সবসময় বলিস যে ওকে। যখনই দেখি প্রবলেমে পড়ে তখনই ওর দিকে আঙুল তুলে দেয়। তো নিজের উচিত যে যেটা দেখাবো সেটা আরো কপি আছে। আমি তো জিজ্ঞেস করি আমার জুনিয়রকে। ভেরি ব্যাড।
My lord's judgment where these notifications has been dealt with.
Very
Earlier, I have failed to, this is, my junior has everything. Has failed, my lord,
Please come back because.
Yes,
this is
yes,
then
yes,
must
yes,
come back
yes.
with instructions.
Well, our duty is to assist the court, not to oppose every time. That is not my duty. But if he wants to place something on, my lord, rely upon a document, I have to go through the same.
If the law is settled, we have to go by it.
I am not on that yet. Yes.
Yes.
And if it appears, yes, if the law is settled, and if it appears eventually that there are other, my lord, the contrary order of other, my lord, coordinate bench, then also my lord has to consider both the judgments.
Yes.
The judgment under order relies upon by my learned friend, and the judgment, if it subsequently I discover that there is some contrary view or something else, then my lord has to consider both. I am not on that. Because, my lord, every time, my lord, we are searching and, my lord, we are developing ourselves. So nothing is that it's a rigid and it is the final today. I am not on that. Only thing, my lord, let him, what about the 95 circular or notification? It may be that
Please hand over a copy.
My lord,
it may be that the subsequent notification, it is at the top, that in supersession of all, then it goes. So I have to consider this.
Please
My
come. The resolution taken by the
কি দেখাবি? কপি দিবি?
State Transport Authority
notification
in its meeting dated 28th April 2023, rejecting the prayer of the petitioner for grant of is challenged in the writ petition. Paragraph, learned counsel for the state respondents seeks to take instructions in this matter. With the affidavit of service. Paragraph, let the matter appear under the same heading on
ওই একটাই গল্প।
6th October.
My lord. My lord.
But in that event, my lord,
Please furnish the earlier
my
judgments.
lord, I shall. My lord, only one thing, my lord, item 288. My lord,
I'll call.
both,
Same.
because the issues are same. They are the refusal, they did not accept the application.
287. 287.
For the respondent Union of India, my lord.
My petition before Rossi applied for trade certificate.
Applied for?
Trade certificate under Rule 34 of the Central Motor Vehicle Bills. My lord, that application has been made, my lord, 5th of February 2023. My lord, page 48, my lord. Now that has been kept pending without any decision. Let them consider, but by this time, my lord, law has been changed also. But it should be brought to your lordship's notice also.
ওখানে দেখিও তাহলে কি
হ্যাঁ, সেটাই দশটা দেখি আমি তাহলে
Placed before the authority that is considered.
Page 48,
Page 48 is the application.
the application form.
Let it be considered, mother. In the consider rule 35(2).
Yes, what do you say?
I'm for the Union of India, my lord.
Let this be considered.
My lord, probably state is the answering respondent in this.
State will be considered.
Well, state will consider, my lord, if your lordship.
Page 48, my lord.
Yes. Considered by the district magistrate.
No.
Who will consider?
Secretary.
Must say, it's not 4.
This one number 4.
4, madam. It is
Regional
not after
transport
officer.
officer. Very good.
Madam, may I submit, madam?
Yes.
If your lordship
Please.
kind submit. Rule 35(2).
নতুন ঢুকেছে এটা তো।
জিনিসটা দেখিয়ে দিই।
না
আমি ওটা consider করবো।
আমি তো রোজ শিখিত
Consider বেশি চাইছি না।
আমি তোমার থেকে শিখিত
আমি
দেখি
consideration বেশি চাইছি।
35(2).
35(2), my lord, your lordship kindly have a glance, madam. Madam, that is, madam. Let them consider in accordance with that.
Let me record this.
Record.
Affidavit of service. The petitioner seeks direction upon the
Applied for trade certificate, madam.
page 38,
Trade certificate.
page
My lord, page 48.
48.
48, my lord, annexure 4.
Page 48.
Seeks a direction upon the concerned authority for issuance of trade certificate in favor of the petitioner. Stop. The petitioner applied for issuance of trade certificate before the authority which was received by the latter LATTER on 5th February 2023. Stop. The application has not been disposed of as yet, nor any trade certificate issued. Paragraph. Learned counsel for the petitioner takes this court to Rule 35 within bracket 2 of the Central Motor Vehicles Rules, 1989, which demonstrates that if such an application is not disposed of within a period of 30 days, the application shall be deemed to be approved and trade certificate shall be deemed to be granted through the portal. PORTL, through the portal. Paragraph. Learned counsel for the state respondents submits that the second respondent be directed to consider the application.
Fourth respondent, madam.
Fourth respondent. The fourth respondent be directed to consider the application in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the application submitted by the petitioner within
4 weeks. 4 weeks.
within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which applicant reported for a week. Thank you.
188. Well, same as item number 186.
No.
So let it be adjourned.
Malad, this
Let
is
it
not
be
that.
adjourned.
This is not that. Malad, here no rejection has yet been, because I intend to make an application.
Let it be considered.
So that has, I failed to deposit because they refused to accept my application. On the same grounds, my lord. The grounds, though it has been not written, because they yet not decided my application, as because I failed to deposit the application that I have. Well, I have taken. Your lordship kindly come to Malad this page 23. Yes, page 23, Malad, the application intended to file, Malad. I think Malad, your lordship will find the route is same to some extent. Malad, there is also covering of Odisha apart.
Yes, yes.
And this Purba Mednipur, Paschim
Also
Mednipur,
7
and the
kilometers
same.
corridor, yes.
But they refused to accept. Then I send it through post.
Lordship,
The
may I
next
come
page.
to answer that? No, let it
Then
be,
I,
let
yes.
it be adjourned for that matter. Because whether the ST, when ST has no jurisdiction, why they have collected the money and application fee and here the matter?
So it depends on the decision taken. That will be taken in the earlier matter.
Yes.
So let this be
Now
adjourned.
then their lordship kindly come to one. Yes. If that be so, your lordship kindly come to pay.
Because if you
Your
succeed
lordship
in
kindly
all
come
the
to page
matters-
30. For my satisfaction, your lordship kindly come to page 30.
Yes.
Malad, this is a decision adopted by the STA. In their meeting, Malad, held on 28th of March 2023. As your lordship got it.
You are Shukdev Das.
Now, your lordship kindly, yeah, no, I annexed a document which shows your lordship will find that page 30 is a minutes of the meeting held on 28th.
This is in connection with others. not
Others.
No, kindly appreciate one thing, the date. Date, very important. Date is 28th of March 2023.
Yes.
Now, they decided to grant, your lordship kindly come to serial number 141.
Yes.
There your lordship will find the route. The Chandonesha, your lordship will find the route. Serial number, my lord, 141. Now, your lordship kindly come to the last column. The application of whatever we permit will be considered subject to fulfillment of the following conditions. Detail, route alignment, something else. But this has to be given.
141 is within the district of Kolkata. Bandstand, Esplanade, Howrah Station.
Serial number 141.
See, page 30 have you lost?
Page 30, yes. Serial number 141. Purnendu Shahu.
This Purnendu Shahu.
Yes.
Purnendu Shahu, your lordship kindly say this route. Your lordship will find the route. Route is in column 1, 2, 3, 4, 5, 6. Route is in column 6. Route is in column 6. At the top, your lordship will find the serial number, then 1, 2, 3, 4, 5, 6. 6 is the route. Then your lordship kindly come down to the last portion, there the route. Masaria to Jhalda. Have your lordship got it? So this is Masaria to Jhalda.
Right-hand column, the decision column. It has no connection with the third column.
These your lordship, they will consider it subject to placement of the route alignment. Now the Masaria to Jhalda, no, what I am submitting, the Masaria to Jhalda is covered another state, that is
Masaria to Jhalda has not been considered by the authority at all. Please see the decision part. The right-hand column, absolute right-hand column.
That's the
common format.
No, this is the common format your lordship will find.
I do not know how
Only-
it is possible.
Now your lordship, then your lordship kindly come to this next page 31. They have issued the offer letter. The page 31. On the basis of that decision, and your lordship will find that the route alignment and the routes.
The region is not stated here.
Your lordship kindly see the route alignment. It's an inter-regional permit. Your lordship, have your lordship got it?
Inter-regional within the
Now,
same
your lordship,
state.
this is the offer letter for the route, the route touch over.
I do not really follow what they have given.
What nowadays they don't give route. They only give applicant number, you have to check it.
The route আমি কোথায় পাবো offer letter?
Offer letter they don't give.
Sorry, my lord, they so far my junior instructed they in the offer letter, it has not been written the whole alignment. It is in the either the permit or in the or with the timetable. It is the
The offer letter doesn't show any alignment at all, any.
no nothing
at all.
nothing. Even the route has not been
The application was for a particular route. It
Yes.
has been allowed for absolutely a different route in Calcutta.
no.
Calcutta, please see the decision, right hand side.
Well, the decision says that that should not, that's restriction, no, notification of restriction, that it will not traverse KMA or that area.
This is common thing which is in all the.
This is in respect of each and every permit which shall not touch the notified portion that is under that notification, the KMA area. These are the conditions. And your lordship will find that.
I think, Mr. Mukherjee, you need to come back, because if you succeed in the earlier writ petition, you automatically.
Then
succeed in this.
automatically it comes, automatically.
It's the same issue.
I fail to understand why you have not made an appeal before the court. What prevented him?
But this jurisdiction
Then his cause of action is more
No,
better.
no, Malala, that cannot be, because it's still the 69(2) is there
All clients are.
and the judgment is there and the notification of 95 is there. How can I apply before the regional transport authority?
I'll adjourn by consent of parties.
My lord, let
Because
it,
since the
let
other
it,
matter is pending,
both these.
by consent of the parties, the matter is adjourned. Paragraph, let the matter appear under the same heading on COVID. 6th October, I said earlier, matter.
6.
286. huh?
Choi,
6th
choi.
October, 6th, same date, 6th October.
যেটা আছে সেটা হোক তারপরে
Item 294. Hearing matter.
SBSC sir, Mr. Banerjee. 294, Mr. Banerjee is appearing for South Bengal State Transport.
Jyoti Prakash Chatterjee last day also he's waiting up to 4:30. Jyoti Prakash Chatterjee.
In which matter?
This matter, particular this matter.
Petitioner. Where is he?
Where is it? Today I have not found.
Mr. Devottam Das is the petitioner. It was adjourned earlier.
But we are keeping on next Tuesday. Because he is দাদা কিছু করলে না বলবে
Month list of October. Petition was not there.
না sorry monthly list of Jyoti
None of this for the petitioner. No accommodation is sought. Paragraph, let the matter appear under the same heading in the monthly list of October 2023.
মধুর আসতে হবে না আমাদের কিছুটা টাকা
Monthly, I'm not calling the monthly list today because attendance is very poor today. Everyone in holiday mood, everyone in a hurry to go home.
I have a matter where not stated 995.
Yes.
The second matter was the hearing. My lord, item number 294. Item number 294, I'm being led by Mr. Chatterjee, my lord.
Do not go back to the matters, sir. I'm in 294, yes.
294.
But just passed an order. You're for the petition.
Monthly list of October. Grateful, my lord.
তুলে দিন, কথা আছে। তুলে দিন, তুলে দিন। Thank you. আচ্ছা। I'll upgrade the monthly list matters to the supplementary list on the next occasion. Group 7 hearing, only group 7 hearing matters. I'll upgrade the first matters to the supplementary list so that they can be taken up.
কবে এটা